I read your lordship's pattern to writ appeal 1449 of 2024. Fresh admission. May I pray your lordship may take up tomorrow. There is a court, but subject to my lord's convenience. Tomorrow or Monday.
So, sir, we will see to it. There are every matters are equally important.
But it was
It will
filed
be-
in May 2024.
So
In application
we are trying to list the matters according to its, may I use the term seniority. So the matter which is senior in, so we wanted to,
it was filed in May 2024.
True, sir.
Which is going to be terminated.
every litigant is equal in eye of law.
Right.
Only one litigant can take your services, such a good services. Others may not.
My lord,
We'll take care of that. We can't assure tomorrow, but it will be listed. Don't worry.
my lord, matter,
Monday.
No.
Humble prayer.
Whatever it will be, sir.
matter formulation of code measures from 2022. And there is likely to be filled up the post and in the last order,
It has not been filled up for 3 years.
my lord, the last order was to list on
Pass on the slip, sir. Pass on the memo.
my lord.
Pass on the memo. Pass on the memo. Please, 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 pass on.
I'm filing this.
Please, pass on the memo. We'll see tomorrow. Don't worry.
Fresh admission item number 1.
My lords, I beg your lordship's pardon to mention, my lords, the content matter of 2016.
Pass on the slip.
My lord, it is not being listed. I have given several memos.
Yes, sir. Pass on. It will definitely.
This
It will come. Don't worry.
this month the petitioner will return, my lord.
Yes, please. Don't mention before the single bench.
Mention because the honorable judge is sitting in a combination of two.
Whatever it will go, don't worry. We have taken a care. It will be assigned in the administrative side.
Mr. Mahathi, Mr. Mahathi, you appraise,
Listed yesterday, madam.
you appraise deputy registrar. That will be placed.
is not extended.
What is there? It's a single bench.
Single bench.
You go there, sir.
is not extended. The report
Sir, it is the wisdom of the honorable judge. You have to convince
No, no.
that is your honorous job.
Is to assign any other bench.
Please,
That's it.
that is not accepted, sir. I tell you, I have a very strong reservations that you could not convince the judge, so the matter should be assigned to some other bench. Sorry.
Mr.
We are not
Mr.
accepting.
Mr. Malik, my lord has expressed the view that you mentioned before the deputy registrar judicial, he will place the file, concerned file before my lord.
It's good there. Write down what is the
In the
reason.
administrative side, he will pass it.
Yes, call the.
Item number 1.
And item number 1, my lord. I mean, pardon, my lord. There is some irregularity in my writ appeal with the paging of my lords, which has been downloaded. Just now I came to know. So your lordship kindly grant me 2 days so that I will remove all the discrepancies.
What are the discrepancies?
My lord, discrepancies, my lord. The paging number, annex of 3, which I have annexed to the writ petition, my clerk has wrongly annexed another ROR. The order of the collector was carried out. Order of the collector was carried out. The said ROR, I have annexed annex of 3.
It is
Where is the act? Can you?
It is a consolidation of holdings and prevention of.
Choose the act.
Yes.
Please. Hey. What are those?
Place, my lord. Validation of the transactions. Any transfer or
Just one minute.
my lord.
One. Let me reach to a relevant
My-
provision.
sorry.
Just have some patience.
When was that amendment?
My lord, 36A.
36 is when was that amendment?
On the amendment, it is on, it is enacted 29/12/2023.
23.
23.
Perhaps it is not.
Then the new act I am just handing over.
This book.
It is.
It is.
Lots.
Sir, it does not contain the amendment. What are you talking? These are all the old books after 23.
হ্যাঁ ওই সেটা তো 2023 মুভ এটা Mr. Devraj, pass on that book. You have the updated book.
Yes, I have given.
Yes, sir.
I have quoted that provision also.
You have the gazette?
Hello?
You have the gazette? Introducing 36A? You don't have?
I don't have right now. I will search it.
Please show us the gazette notifications, because the language is such that so far as any transfer or partition which has already been done prior to coming in force of the act, that would be treated as a valid one.
That is my.
And then the proviso says,
If it is
I do
acted
not
upon.
know what is the meaning of this word, shall not be reopened. I do
Mine.
not know what is the meaning of this word reopened.
If it has been acted upon.
Acted upon,
That means
That
if
is
it
the
is not
language of-
acted upon,
my lord.
then what?
I'll find out the gazette, my lord.
Get a print book. Yes,
Any adjudication which has already been done.
get a printout copy of it. नल दीजिए शेयर कर दिया सर शेयर दिस इज कमिंग टू फोर्स अप्लाइज
Absolutely. That is what my impression was.
It is there. Yes, sir.
Yes, that is the proviso where any not a commitment as omitted in this city shall not be reopened. What is the meaning of reopening?
চিকন কলে শুনলু একটু ছিল তো I have appeared. They have to provide me copy. In both the cases, I have appeared.
Yeah. Respondent number 1.
Yes, Binoyini. Bijoyini.
Mr. Devraj, you are appearing for
Collector.
Collector.
My order has been set aside.
Respondent.
2. Respondent number 2.
Yes.
In fact, your lordship was deliberating on the effect of the amendment.
Contesting respondent.
He is a contestant. I am the contesting respondent. I am the petitioner before the Honorable Single Judge, and the order has been set aside. The amendment says whatever transfer has been effected prior to the commencement of the amending act, those will be valid subject to the provision, namely where the possession has been delivered. Here, the impugned order was passed directing delivery of possession, but that was stayed by this noble court in the writ petition. So the possession has not been delivered. Considering that, the Honorable Single Judge.
Mr. Misra, Mr. Misra,
My lord.
Mr. Bhaskar Panda has not yet opened his brief.
I'm so sorry. I couldn't hear because your lordships were muted. I couldn't hear. I'm so sorry, my lord. I'm so sorry, my lord.
Now, by virtue of this amendment,
My lord,
under section 36A, when it is introduced,
my lord.
there has been a deletion of certain provisions of the, like section
My-
35,
34 and
34. These are the provisions which have been deleted
My lord.
or omitted. I do not know. That's why we wanted that particular, the notification. What was the reason of its omission? Because these are all the, I would say, the penal provision in that sense.
Mine.
It is not in that panel under the criminal law, but it is really a penal provision because one loses his right
My lord.
in respect of a property.
My lord.
So I just wanted to see that what necessitated the
Bring the-
government to bring those amendments and delete those provisions.
Your
The
lordship,
very core object is frustrated by that.
my lord.
If you delete section 35,
34
then the very core object of this act goes.
My lord.
Chapter 5, that,
My Chapter 5.
section 2 of the Amendment Act,
My lord.
that says that in this, in the OCHPFL Act 1972, chapter 5 shall be omitted.
My lord.
Shall be omitted.
Right.
So it has no retrospectivity. Omission is only prospective.
Perspective.
Because section 1, subsection 2 of that gazette says they shall come into force at once.
My lord.
That means on the date of publication of the gazette.
My lord. And proviso.
No, on the date, yes, Odisha General Clause Act.
My lord. Now proviso. Your lordship, I am placing just
It has come into force then with effect from 29th December 2023.
23.
So any transfer effected prior thereto,
My lord.
whether they remain as such or they cannot be reopened, that is what we have.
But
Proviso-
proviso is very clear, my lord.
Yes.
This provision is nowhere challenged in this code.
Iris has
I
not been
think-
challenged through this
I
amendment.
think it is there. I think. I'll check it out.
But I will verify, but.
And that is to be verified, but
The
relying
amendment-
upon this amendment,
You
number
must
of
know-
judgments have been delivered.
You must be knowing,
Yes, yes, my lord.
because you have been dealing with this since long, and Mr. Misra also.
My lord, I'll examine.
Madam, there are number of judgments accepting this. Challenge to the virus of this amendment has not been possibly made subject to correction because as on today, as I understand, my lord, this amendment has been accepted and number of orders have been passed.
On basis of that.
Yes, yes. I have also, by another single judges, I have come with 2 judgments, my lord.
Have you applied your mind on the amendments?
My lord.
Have you thought of seriously of this amendment?
No, my lord, yes, about virus I have not.
Have you thought of what is the object of this, the act? The act to provide for consolidation of a holding, that's the very preamble
My lord.
of this act. Consolidation of a holding and prevention of fragmentation of a land.
My lord.
These are the twin objects for which this act has been enacted.
My lord.
And the prevention of fragmentation, the relating clauses prevention is provided in chapter 5.
Exactly.
is no
Chapter
omitted.
five.
The chapter 5
As you know,
with lock, stock and barrel is deleted.
that.
What is the effect? If the object of the act was something else, can you go against the very spirit of the object
No, my lord.
and the purpose of the act? Can you? Can it be done? That means you are permitting the fragmentation.
My lord.
Then you are offending the very object when the act was introduced. This is what is.
This is the very.
That is what I'm saying. There's a preamble if you look at.
Yes, ma'am.
And statement of objects and reasons.
Yes, ma'am.
For introduction of that.
So have you never thought of seriously? And the chapter 5, the head note is, the broad heading is prevention of fragmentation.
My lord.
And this entire chapter is deleted.
May I please one thing, my lord?
You're absolutely correct.
Your lordship can be.
Agricultural production in the country.
Absolutely.
And in person, the same thing.
That is what is.
Because in every state, after the agrarian reforms really came, then every state within its power, means the stateless, they enacted the law to prevent this agricultural land.
My lord.
And this, our state has also enacted it. The object is that the consolidation of the land, avoidance of a fragmentation. Because if a big chunk of land is used for agricultural purposes, then it will yield more produces.
More production.
If it is used in a very small fragmented manner, then the produce would be less.
Modern technology cannot improve.
That is why this act was introduced. Consolidation, avoidance of fragmentation. And the fragmentation is permitted by this amendment.
36A.
Can it be?
Your lordship kindly call it some other day.
Can I use that basic structure theory? Where is the object?
None that.
Can you? That's a basic structure on which the law is enacted.
In fact, in one of the judgment, while dealing with 34 and 35, the Honorable Court, Honorable Division Bench has been pleased to observe section 34 and 35 are the heart and soul of the statute.
Has to be.
My lord.
Has to be. No, query to that. I think even the entire chapter 5 is the important provisions. What to do, sir?
He wants some adjournment.
In my case, my lord.
Give.
In my case, my lord. Your lordship kindly.
Ponder upon the thing, sir. You are in I would say, in a disadvantageous position. And second thing, I am really surprised that the provision under chapter 5 talks about the auction amongst the adjoining owners.
Lot owners.
Why not an auction amongst the co-sharer? They have a first lien and a right.
Right.
Why adjoining owner will step in? Land is owned by several co-sharers. There are several co-sharers, say 5 co-sharers, they inherited from their father. If one of the son wanted to sell his share, 1/5 share, undivided, then the adjoining owners will have an auction. Then it will again propagate the fragmentation. Because he will go for a partition of the property and to include within his adjoining land. So it must be amongst the co-sharers first.
Yes.
So that it remains within the family. Anyhow, ponder upon the things, sir.
My lord, I'll examine
Examine. I know your eviction order has gone. Your eviction order has gone.
Yes, my lord.
No. So let us, I think Mr. Counsel is very much interested in protecting the interests,
My lord.
being a beneficiary of this order.
My lord.
So ponder upon the thing, come up, argue. There are 2-3 points you'll have to argue. What was the necessity for bringing this particular amendment act? And whether after the deletion of the entire chapter 5,
My lord,
what is the effect
my lord.
and how to harmonize this particular amendment, section 36A? Can it be given to a retrospective effect or it has to be given a prospective effect?
My lord,
You have to come and argue those propositions.
my lord.
If it is prospective in nature, then whatever is there is saved. If it is retrospective, then whatever has been done, gone.
In Bhagavati still, I think Honorable Supreme Court has interpreted what is omission, deletion
That is,
by way of
yes,
amendment.
that is what is there.
My lord. Let's say, can I call it some other day? There are also discrepancy. I will correct it and
Yes. Leave is granted to the applicant to remove the defects as pointed out by the registrar. When
yeah.
Let my friend also provide copy to my associate in both the cases.
My lord.
when
My lord, next week, after removing the defect, I will file a
after
consolidated
10
appeal.
days, they give a date after 10 days.
I will
Yes,
file a consolidated appeal.
14th.
come.
Item number 2.
Is called the
Item 2.
item number 2.
Petitioner is the appellant, my lord. Challenge before the Honorable
Where is the impugned order?
order,
Annexure 7.
Annex of 7, page 44.
Yes. Your pension is
5% pension
is withheld for 1 year.
Yes, 1 year.
1 year has gone.
1 year. Till date, they have not paid any pension, my lord. Till today, they have not paid any.
5% was withheld. Now 1 year has gone from the date of imposition. So what? He's entitled.
Will take instruction in that whether pension has been paid, but as per the rule 7, that your lordship see that para 7 of the judgment, page 15.
Oh, he has challenged that particular order.
Yes.
The honorable judge has come to the conclusion that there are rules and there, so that can be done. But it was withholding of 5% of the
For
pension
1
for
year.
1 year.
Yes.
So now 1 year has already expired. Why you will not pay the pension?
Lordship direct that.
Is an easy solution for that.
That's well, your lordship direct that.
No,
What direct?
you will get the instruction, sir. Why you are not paying?
I will take it.
If
Also,
only,
you are
only,
entitled to full pension, no
only
difficulty.
5%.
5% only for
Each
1
month.
year.
1 year.
1 year for one.
That order also without rule, my lord, without illegal.
Whatever. Now this chapter is over.
Yes.
Would you still continue fighting? 1 year has gone.
Yes.
Only 5% amount. Nothing.
My lord, if that.
You cannot get
Yes,
you
ma'am.
cannot get new employment.
No.
You have already attained the
Retired since
age.
2018.
So,
I retired since 2018.
correct. So it's over. 1 year is over.
Another, if the order will sustain, my lord, then I will, my promotion is kept in the seal cover, my lord. That
You
will, I will-
can't. Now you have retired, sir.
even retrospective promotion, I will only get the
Still have a promotion.
I will get the benefits of the pension post.
Anyhow, come with the instructions.
Yes.
Let us see. Yes, when?
2 statement.
Short death order.
Give. Yes, all the links.
Item number 3.
Mr. Degra,
May I please, your lordship?
6 recommendation to obtain instruction with regard to payment of pension as directed.
Item number 3.
Please, your lordship.
Yes.
The petition for your lordship.
Can you any construction, sir? Can you make any construction beyond your demise premises? Means the lease
I have
premises.
I have not made any construction beyond the
So,
premises.
if they have demolished the temporary gate, no difficulty. You are not an affected person, sir.
No, my lord, I'll just clarify one thing. I'm also questioning the authority saying that the land in question is a GA land, has not been handed over to the municipality. So municipality has no domain to issue a notice and direct demolition. My lord, that is what is essential. My challenge.
Demolition of, please, sir, demolition of a structure which does not belong to you.
Here,
Is
what has happened?
not
If
saying
you
it
see,
does not.
now, may I just point out one thing? Why I am aggrieved? Your lordship may kindly turn to page 29.
Please
Page
answer
29,
me, answer a very simple question.
my
This temporary gate, it was constructed over your leased property or outside the leased property?
no, my lord, this is towards on the entrance to
I
protect
am
the property
asking
from
you,
any.
sir, lease you have annexed. The boundary of the lease is also given in the lease deed, I have seen. Please tell
My-
me this temporary gate was constructed outside that boundary limit or within the boundary limit? Very
Outside the
simple.
boundary limit, your lordship.
Outside.
Outside
Then
the
you are
boundary
not an
limit.
agreed
Yes.
person, sir, then why you are bothering about it?
No,
Whoever-
why I am bothering, I am just assisting your lordship. Why I am bothering? Your lordship may kindly turn to page 29 since your lordship has been pleased to see it. Page 29, the map that was annexed to the list deed. Your lordship may kindly see that. Here the municipality, I'm essentially challenging the jurisdiction and inconvenience your lordship will see. I'll just point out. Your lordship sees towards the top that 20 feet wide road. Your lordship got it, my lord. Page 29. Both the sides, your lordship will find there is municipality road, and by the side of the road, the footpath is there. So this 20 feet wide road is not accessible to the main road, nor used as a passage by anyone except this karate school. For the reason, your lordship will find it the two other organizations, namely Bharat Kaushik Samaj and Ekamra Satya Seva Ashram. All these are having access to the left and right hand side. So they don't have access to the 20 feet wide road. It is only the karate school which is having access to the 20 feet wide road, from where they will go to the municipal road, your lordship. Now, in order to protect any invasion, because these kids and other people are and even the government officials are taking training in that school, two gates were put on the extreme side of the road. That is only to prevent any untoward incident and other things. And your lordship will find from the photograph, it is not encroached upon, because your lordship may kindly see the photograph. There are number of trees. Your lordship may kindly turn to page 38. Page 38, your lordship. Page 38. The road which I have shown to your lordship in page 29 is this. That is page 38. Your lordship sees the permanent trees are there. It is not that any motorable road or anything. Your lordship sees the trees, page 38, page 39, and everything. So that was only in the extreme end of the road. Two gates were fixed just to prevent any unauthorized entry and other things. So, and this particular land has not been handed over government to the municipality. So municipality will exercise its jurisdiction only where the government has handed over the land. Here it has not been handed over. That's my case. And this is not accessible to the road at all, because there is a footpath by the side of the road on both the sides. I have indicated to your lordship.
The property over which you are making a claim, does it come in the municipal area or municipal corporation area?
No, that is my stand.
That is.
It doesn't come. That is the only
Show me
stand.
the territorial, show me the territorial limits of the corporation or a
But
municipal. So every
that is only from the.
municipal corporation has a territorial limits. Show us what is the territorial limit.
Now here, what I humbly beg to submit, that these are all GA lands which is allotted giving a road. So that is not handed over to the municipality, because municipal road, your lordship will find from page 29 is on the both sides. And all the institutions that have been allotted with land have access to the public road directly. Whereas the school has to access through the 20 feet wide road where there are trees, your lordship.
Yes.
In fact, when the matter was in the list before the previous honorable bench, and though no order was passed, the council appearing for the state was instructed to maintain the status quo till the matter is taken up. Despite such situation, they have removed one gate, they have damaged. I have filed an affidavit bringing those things on record. And yes, there was a letter from the government council. If I am correct, it must be available in my friend's record to the state authorities and municipal authorities not to, because that was the observation of the honorable bench when it was listed. Now, my lord, what has happened was this will create lot of problem. But therefore, I am only questioning my lord, the municipality. The state government has not taken any action against me. State government has not said that putting these gates is illegal, so therefore you should remove it. Municipality who has no authority has done it. Therefore, I am before your lordship. And my lord, your lordship sees the impugned order. My application could have been, writ petition could have been rejected. But here, the honorable single judge directs that remove it within a time limit. That was never the prayer, nor anyone sought for. So the honorable, while rejecting my case, has been pleased to direct your lordship will see paragraph 6, page 37. That has created another problem, your lordship.
Yes, that's all.
But this short, no, I have to assist, nothing beyond that, man.
Yes. The illegal and unauthorized constructions blocking the access through a road is demolished by the Bhubaneswar Municipal Corporation. Which is challenged by the appellant in the writ petition. It is a specific stand taken in the said writ petition that the appellant was put into position on the strength of a deed of lease executed by the government in its favor. And the terms and conditions embodied therein would clearly indicate that uninterrupted use and occupation of the demised land is assured by the government. The lease deed contains the boundaries of the land demised unto the appellant, indicating that on the north it is butted by 20-foot wide road, and on the other sides of the road there is a plot owned by different persons. The lessee cannot expand his horizon beyond the leased land, nor can claim any right in respect of a land beyond the boundaries set forth therein. Right to access to the land is an easementary right and cannot be curtailed. It is not a specific, it is not a case made out, no, it is, sorry, the appellant never made out a case that the action of the municipal corporation creates any hindrance in free access to the demised land. But the temporary gates were fixed on the road, which was found by the municipal corporation to have been made illegal. No individual would be permitted to take the law in his own hands and act in complete defiance thereof. The construction of any structure is regulated by a relevant statute, and in absence of any permission having granted by a competent authority, such unauthorized and illegal construction should not be permitted to remain. Full stop. Admittedly, the temporary gates were fixed on the roads, impeding the free access, which according to the appellant was fixed to ensure the safety and security of the students of the appellant's institution. It is fervently submitted that all other plot owners does not impede the free access to their respective land, and precisely for such reason there was no objection ever raised by the aforesaid plot holders. Stop. It is immaterial whether any objection is raised by the other plot owners. The moment the structure is found to have been made illegally and in violation of the statutory provisions. It is unimaginable that a person will be permitted to to affix a gate on the public road in the garb of that it would ensure the proper safety and the security of the inmates of the said locality. The appellant, after realizing such predicament as appear in this regard, vociferously submits that the land was never included or handed over to the municipal corporation, and therefore it was outside the territorial limits. Stop. It is thus submitted that the moment the property is outside the territorial limit of the municipal corporation, the corporation cannot overreach the same and demolish / remove the temporary gate fixed on the road. We are not impressed with the aforesaid submissions. The Bhubaneswar Municipal Corporation is created on the strength of an act having passed in the State Assembly, and the territorial limits have been assigned. Even a government land even a land owned and possessed by the government is situated within that municipal corporation limit, it does not mean that the said land is outside the territorial jurisdiction of the said municipal corporation. Once an unauthorized and illegal construction is found to have been made by an authority in respect of a property situated within the peripheral of the said municipal corporation, there is no fetter on the part of the municipal corporation to remove/demolish the said unauthorized/illegal construction. To stop. We thus do not find that there is any illegality and or infirmity in the order of the single bench. Stop. The appeal sans merit. Full stop. The same is hereby dismissed. Since the main appeal is dismissed, the interlocutory applications filed in connection therewith is also dismissed. No cost. Call the next.
No. Item number 4.
My lords, pursuant to the last order. Report and the status of the road, my lords.
Just I received the affidavit filed by my learned friend.
Have you got the instruction?
Yes.
You were directed to
Yes,
give
my lords, we have filed an affidavit to that effect, my lords, short affidavit, my lords.
Yes.
Page number 3, my lords. If I may,
Just now I received.
page number 3 describes why there was a delay in the completion of the work, and page number 4 is the present status of the road, my lords.
Their grievance is that you are making a road and you cannot continue eternally for all time to come.
No,
You
but
have
it's
to
now-
finish the work within a time frame and then let
That-
them utilize
Yes. The
and-
work has started, my
and
lords.
get the benefit of that road.
Yes, my lords.
With an undertaking, your lordship dispose matter, how much time is required for a completion of the road?
Can you? You do not know, unforeseen circumstances may come. Nobody can foresee that it may come. We have said that certain trees that they fell on that particular thing.
My lords, if I may refer
Because
to
of
page number 4, now all efforts are being taken to complete the road, my lords.
how much time, how much stretch is still?
So, my lords, first layer is complete. The one last bituminous layer is yet to be completed. That is going on. My lords, if I may refer to para 6, page number 5.
This is a very ambiguous word, couple of months. What is that? What does it mean? Couple of months.
My lords, exact time period could not be mentioned, my lords, but all efforts are being taken, my lords. The work has started also, my lords.
Rainy seasonings fast ensuing.
Understand, my lords. But my lords, one layer is complete, the last layer, which is the,
Bitumen is very important.
yes, my lord,
If
bituminous
you
layer.
do it in a rainy season, what will happen?
My lords, last, if I may refer to page number 4, last 5 lines, my lords. All steps are being taken for early completion of the project and should be completed soon, my lords. And all the problems which were raised has now complete and the project has started working.
Just after your lordship interference, work has been started. With your lordship permission, this is the progressive work is now going on.
the video recording of that area.
What, no progress?
The slow progress is there. Video recording, entire recording is here.
Don't make construction with a snail pace.
No, my lords.
Water has not been spared. Heavy dust is there.
Activate.
Yes, my lords.
Nowadays, the entire society is moving fast because of the technological advancement that has come. Now, roads also they can be made by using the technology.
Has not used modern technology. It is proof not used. There are some laborer is there that taking the chips and speeding in the road.
Yes, but
A time taking process.
My lords, in light of this, my lords, if I may request, because the work has started and I had spoken with the engineer.
Started. That is admitted fact that is started.
the writ petition in the nature of a public litigation is filed by the petitioner, flagging an issue that despite the rural development department having taken an initiative to construct a road from Katrapara village to Alenka Sahi, in order to connect the same with Katak-Chandabali Road, there is no progress having shown in this regard. And the villagers of the 5 villages having more than 8,000 populations are suffering. Stop.
Last 2 years.
Oh, it is further alleged that though the expansion work under the said project ensued in the year 2023, but subsequently no progress was made as the work was stalled for the reason unknown to the villagers of the aforesaid 5 villages. Despite several representations having made to the concerned authority, no progress have been, no decision has yet been taken. Stop. The matter was moved, next paragraph, the matter was moved before us and a direction was passed upon the state to take instruction, disclosing the steps having taken to complete the said project. An affidavit is filed by the state which reveal that because of the non-shifting of the utility like an electric pole and the falling of the trees on the road, as well as the disturbance created by the local public, the contractor was not able to execute and complete the work. The report further revealed that the complaint is also registered. And the initiative to start the said ongoing work has been undertaken after the intervention of the Gram Panchayat Samiti members and the villagers. It is an obligation of the sovereign to complete the project once the initiative in this regard is taken, and cannot be permitted to continue perpetually. A conscious decision was taken by the department to construct the said road connecting the main road for the benefit of the inhabitants of the nearby villages, which is one of the onerous duties cast upon them under the federal system of governance. The allegations and counter allegations are made from the respective corners, which in our opinion should not impede the progress, nor should hamper the very object for which the project was undertaken. We find that several layers have already been laid to strengthen the sustainability of the road, and also to bear the load of the heavy vehicles, and the bitumen layer is yet to be made, for which the state needs some more time. Stop. The pith and substance, as it appears from the respective stands and the pleadings made in this regard, that the construction must reach to its destination and cannot be kept unfinished in the midway. Since the construction work has resumed after removing all the impasse that was faced by the contractor, as revealed in the said affidavit, we expect that the same would be done by showing alacrity. Stop. We therefore since the purpose, the core object for filing the instant public interest litigation is subserved after the commencement of the work of the said road, we therefore direct the state to complete the same within a reasonable time. Stop. The state will keep in mind the difficulties faced by the villagers who would be the beneficiary of who will be the beneficiary thereof. And the responsible officer of the department would monitor the progress of the said work so that there is no lackadaisical attitude, no dormant or lethargic attitude is shown by the contractor. Stop. Disposed of. What more? Time limit is difficult, sir. Very difficult. You can't put it within a bracket. Otherwise, that will give you another chance to come. Never done. Never done. In these, I have not experienced their time limit. No.
Your Lordship, fixed time, I will never
No,
come
no,
before
it's
you.
not.
Again, I will
No,
never
no,
come
no,
before your Lordship.
Not.
Item number 5. Item 5, sir.
Lordship, we have filed the counter affidavit today in the morning itself. And we're serving a copy on the.
So you already served, then he returned, then again.
So he said that let first pray before the court and then I will accept it.
But I have to go through this and take instruction from my client.
That is a brethren fraternity. If somebody is giving you a copy, accept it.
Sorry.
It's a difficulty. Why you wanted an exhibits?
No, not exhibition, my lord.
These are the exhibits that exhibits before the court that now from the left hand, it has come to my right hand. That's an exhibit.
I have to take instruction on this one.
Take it, but why you will return it?
So that
does not.
I apologize for that, my lord.
These are all brethren fraternity, as we call it a noble profession. Never refuse. Yes. The counter affidavit is served upon the counsel appearing for the petitioner who prays for an accommodation to peruse the same.
My interim application is there because the likelihood of them
Sir,
approach my.
You have to take one plea. Either you argue the matter, or if you want to peruse, then you.
Because I have to peruse because with
Then
them.
come after 10 days.
No. Item 6.
Item 6, may I please? So the petitioner is a IMFL on-shop licensee, and he has challenged that he has been debarred from lifting 180 ml liquor bottles, my lord. And
Why? Now the 180 is permitted.
Permitted, your lordship.
Lordship, in the similar cases.
On 5th.
I do not know what is the utility of this, because these are all online.
Yes, your lordship.
These are on-shop license. Then why I
In
do
the
not.
cases of an interim order, your lordship, they are being allowed to.
Consume. Off-shop and on-shop, I know. But the concept is something different, which I, can you stop?
On 5th.
How can it be? There is already a judgment. I think I have also.
Yes, my lord.
Yes,
Same.
Yes, miss, I have annexed 6. I have annexed it. It's annexed to my writ petition. Judgment on 7th April.
Item 11.
In terms of this order, I think remains to be executed. This is the point is.
Let's Honorable Justice Muralidharji's judgment is at Annexure 6 to my writ petition.
That is quoted
No, no.
by me.
Yes, Your Lordship, I quoted it.
Have you seen this?
Milord?
Have you seen this latest one?
Latest one is by Lordships.
Yes, yes.
7th April. I have.
So I have already
Yeah,
quoted those.
Yes, Milord.
So what remains? In terms of this,
Yes, yes.
your petition is allowed. Mr. Kanwal Shila. Challenge this. In terms of this judgment, nothing remains to be adjudicated, and the reflection is allowed. In this now why don't the puppets one? Lekhi Devi.
Yes, sir.
Item 11.
May it please, my lords, in absence of the GST tribunal, we have challenged the order of the first appellate authority. My lord, same.
10%.
My lord.
We are keeping this matter
My lord.
alive. My brother has kept it.
My lord.
Same thing.
For the interest of revenue.
Yes.
Grateful, my lord.
Item 12.
Item 12, your lordship, was a RC cancellation matter.
Same.
No, this is what is here. This particular is disposed.
Item 13.
May it please, my lords. Petitioner, my lord, is a industrial unit, my lords. Unfortunately, my lord, after an audit was undertaken, demands were made in the show cause for all the fees I pay for all sorts of licenses, beginning from fire, municipal license, all site of licenses, beginning from municipal licenses, panchayati licenses, fire, and fortunately, my lord, after I showed cause in the adjudication order, all those things, weighing bridge inspection licenses, these were dropped. It was, my lord, demanded on 3 counts: the license for the under the Factories Act, the pollution license, the fees I pay, and so far as the food, my lord, license which I procure in the canteens maintained in the factory premises, the fees which is paid to the government on this, lord, was held to be a supply by the government, and as it was made to be a supply by the government under the reverse charge mechanism, my lord, a demand was made to pay, my lords. My humble contention, my lord, is
that those license fees are not liable.
My lords, that this, my lord, in my humble submission,
These are the statutory imposition.
My lords, and these are core functions of the government, my lords. I'll not use the word sovereign functions, core functions, my lord, to ensure there is a just and humane conditions maintained in the factory premises for the workers, my lord. And the Factories Act, my lord, it stipulates that these licenses have statutory because we will be under the supervision of the factory inspectors who have a whole host of activities to see to it that the factory.
Where is an order?
My lord, the order, my lord, is at page Annexure 6, beginning at page 95. The discussion, my lord, begins at page 112.
Section 74.
Section 74, my lords. And unfortunately, my lord, that is also my second limb of argument, that this particular.
I think this is one of the oldest industries.
Industry in my lords. Paper industry, and unfortunately, the only surviving industry in the state, my lord, which is running. If your lordship would kindly turn. 112 people.
ଲଟେରୀ ଚାପିକି ମାରିଦେବେ ଆଉ ଇଣ୍ଡଷ୍ଟ୍ରି ତ ଗଲାଣି IPR ପରେ ସବୁ ଇଣ୍ଡଷ୍ଟ୍ରି ଗଲାଣି ଏଇ ଗୋଟେ ଚାଲିଛି
Lordship, as per section 7, scope of supply, there is a word license. On that ground, the department has taken into consideration.
So if you
As a,
It's not a license in that sense. It's a permission in that sense. That one, unless you take a permission, you will not be able to run it.
section
And in order to have permission, it is really a fees. License is something different. It has a wide connotations, but one has to understand in the perspective because what he's giving is giving to a government. It's going from one organ of the body to another organ of the body, nothing more than that.
And unfortunately, my lord, this particular aspect, my lord, was compulsory under the Factories Act now. Section 6, my lord.
There are. Now the pollution has also intervened.
Months. Because air and water pollution licenses are a must. And the FSSI AI license.
In a paper industry is more.
More.
Because you are imbalancing the ecological system.
True, my lord. And as a
admits.
I admit, my lord, but those are, my lord, corrective measures which I take, my lord, because I'll be under the supervision of the Pollution Control Board, my lords. I can't release effluents without treating them. I can't, my lord, pile up garbages inside the factory premises. So those are, my lord, under the Factories Act, I am prevented, as well as under the Pollution Control Act, my lords. So air and water pollution, my lord, are something very primary, my lord.
Stamping and verification way bridges.
That fortunately was allowed. Initially, my lord, initially
you are taken up under 74. You have taken up prima facie, you are satisfied.
This was,
and you are taken up under 74.
Why it has been come under section 74 after one should file the return under section 39 when it's self-assessment. After the audit was conducted, your lordship.
Everything under the sky, beneath the earth.
And there's no fraud committed, my lord, because these are from my very ledgers.
After verification and audit, they have invoked section 74.
So that's why
the only reason here.
Prima facie you are satisfied. That's why you have taken up this issue.
We want to hear. This is an interesting one. What is the total amount?
My lord, total amount, my lord, is, my lord's 5 lakhs 77,000. Equal amount of penalty and then interest.
Without prejudice, the use is a company of the paper.
The company may be a huge entity, my lord, but so far as my economics are concerned, my lord, it's very much squeezed.
The deposit without prejudice, no difficult. 5 lakhs is peanut.
No, equal amount of penalty
for you.
No, equal amount of penalty.
That also is a peanut for you. What's the total turnover?
With great respect, my lord.
What is the total turnover?
But I have not verified, my lord. I'm sorry, my lord. I have not checked that.
No, you have. You should have.
I should have, my lord. I should have. No. I owe that duty, my lord, but unfortunately, I have not. But may I just pray, my lord?
No. Principally, what you say, let us hear out the matter.
No.
Let us see whether they can include it or they cannot include it. I know there is a right of an appeal, but still, see, it goes at the root, strikes at the root we wanted to dispose of. That whether these kind of fees that can be.
Okay. And your lordships have also interfered, my lord, right from 1718 to 2021. They have clubbed up the entire 3 years, my lords, and they have demanded this.
So that we have already kept it.
And there your lordships have also granted stay in those matters. I have 3 points in this case. The very taxability of these license fees. No proceeding can be initiated at 74 because from the audit, from my ledger, my lord, they brought out this. As per their own notification, my lord, I have also annexed this. that they have to first establish there was a fraudulent activity not to pay tax.
I understand that you say that I have disclosed everything and I have taken a conscious decision that this will not come under the purview of the GST. You have already shown it. It's not that you have suppressed it or you have claimed consciously according to you does not.
Very much obliged, very much obliged.
There cannot be any element of fraud that can be imputed to your act. We understand.
And
this is why we wanted to hear out the matter that how this concept of fraud is to be understood in the fiscal statute.
And the CBIC, my lord, has
like a civil or like a criminal or something hybrid.
And the CBIC itself has come out, my lord. I have annexed, my lord. The CBIC has also, my lord, come out, my lord.
So
non-payment.
Since you are a no difficulty, well-known company.
No, to
deposit 10-15 lakhs rupees is not a.
No, may I just humbly pray, my lord. I'll not bargain with your lordships, my lord. Your lordship may permit me, my lords, to pay 10% of it.
This is the part of that big group.
Imami, they have a registered the office in Calcutta, my lords. And
it's a big group, sir.
It's a big group, but so far as Orissa activities are concerned, my lords, it's
it is all consolidated.
Humbly pray, my lord, without joining
deposit.
May I just humbly pray, my lord? I may be permitted to pay 10%, my lord.
What?
Of the tax.
That would be demeaning the stature of the company.
Unfortunately. So I'll leave it to your lordship.
But then in that event full, we should also respect their stature. 10% is then we'll have to forgo everything. That don't pay.
That is below the. No, that is what I could have normally paid had I gone for an appeal, my lords.
Had you gone for an appeal?
Since I've come to the High Court, my lord. Since I've come to the High Court.
You had gone to the appellate authority. What is the condition, President?
10% of the tax, my lord.
10 or more?
10, my lord.
20?
No, my lord, 10%. 10% of the first appellate authorities, my lord. 107 speaks of 10%.
Of the total?
Of the tax, my lords, without penalty and interest. Yeah, that interest has not been quantified also. I'd only beseech both your lordships,
I'm in favor of 100%.
My humble submission would be 10 minutes.
And let my brother, whatever he decides that.
Since I've made out a prima facie case, my lord.
That is interesting.
Sorry, my lords.
Any instruction?
No, my lords. My learned friend was saying that please put forth the joint tax periods in one show cause. I said that I've already conveyed to your lordships.
I think Mr. Madhaulal Agrawal, since inception of this company, he is the only counsel engaged.
Unfortunately, he has given me a chance to appear before the company.
Mr. Kaur, this reminds me of carbon credit, which we were defending.
That was long time back, lords. So,
yes.
Our side of the argument for the petitioners.
We will hear out.
Sorry, my lords.
We'll hear out.
On all the 3 points, my lords.
Should I? The interesting point is raised in the instant writ petition as to whether a single show cause notice covering multiple assessment years is valid in the eye of law. Semicolon. Secondly, the license fees paid to the statutory organizations.
Pollution license fees?
That's license fees.
You would get it.
To the statutory organizations shall come within the purview of the GST and can be reopened by initiating a proceeding under section 74 of the GST Act, being an act of fraud. Full stop. We are conscious that there is an alternative remedy by way of an appeal, but since the point raised before us has a larger impact, we decided to determine the aforesaid points. Stop. The respondents are directed. What is
Department.
What is the term used? There we use respondents. That's why I'm asking.
Opposite party.
Opposite parties.
The opposite parties are directed to file their
Numbers?
counter.
1 and 1, 2.
Is it required? Because it is a pure question of law. I don't think there is any dispute of the fact.
I am for 2, 3, 4 year lordship.
Please, will you or should I record dispensation? That's why I'm asking.
I am appealing for opposite party number 2, 3.
Counter.
Counter within 2 weeks, your lord.
Would you like to file? It's a pure question of law.
I'll be filing.
You will file alternative remedy. But we have
Counter.
already-
We have already foreclosed the door. We knew it.
I agree.
That's why we recorded. I am conscious to file counter affidavit within 2 weeks from date. List the matter immediately thereafter. No, list the matter after the vacation. In order,
no need to 1 and 5.
1 and 5?
No, not this.
the service of notice of appeal upon the respondent opposite party number 1 and 5
Union of India and the GST Council. Not, for the time being, your lordship will dispense it.
is dispensed with for the time being. Since the demand is made upon adjudicating under section 74 of the GST Act, had the petitioner exhausted the statutory remedy, the mandate of the provision envisages the deposit of 10% of the tax amount, and therefore we direct the petitioner to deposit. Pricking to my conscience, 10% of the tax demanded with the concerned authority within a week from date.
Balance.
Any date after
24th June.
24th June.
And the stipulation is once I pay this 10%, the balance is
in
paid.
the event of the payment of the amount as indicated here in our the opposite parties, the appearing opposite parties are directed not to take any coercive steps or further steps on the basis of the impugned order.
That your lordship have really balanced the equities between the state and the assessee notes.
No action will be taken.
Of course, equities may not be even applicable exactly for the tax, but still your lordship. Greatly obliged.
Item 14.
This is a matter touching that claim of fighting on 16(2)(c), which your lordship have been examined. 16(2)(c). I have paid tax. Supplier has, instead of depositing, not paid. That is a IT reverse. Whereas I have approached this honorable court challenging the show cause notice. Your lordship, I have now filed an amendment application IA 2942/25. I have annexed a copy of the order passed by coordinate bench of this honorable court at page 22. Your lordship has granted me liberty. If any adverse order is passed, after reply is filed, then you can approach. Because that is how I am before lordship now. So now they have raised demand, and that is why I have filed the order of assessment. I have taken on record by amendment. Your lordship may kindly allow amendment, and I have also filed another IA for interim stay, and that interim stay that will follow as per my lord's order. In my case also, yesterday one I appeared. And also many cases are there.
Now, suppose an order has come in the midst of the instant writ petition, then definitely being a subsequent event, the amendment can be allowed so that they can assail that order as well. So there is no difficulty.
Your lordship, no difficulty. Your lordship, I have figured out some of the petitions which are pending. So far as this 16(2)(c) constitutional
validity, consolidate everything and then fix a matter.
Correct. These are some of the matters. Since long, these matters have been, your lordship, pending.
It's the matter 24th June.
Your lordship, let this order may be passed. So far as the interim order, this honorable court, in catenav cases, your lordship, so far as the constitutional validity matters, your lordship, has granted a conditional stay. My Lord, Honorable Justice Raman is also a party in that order. Your lordship, 20%, without 20%. In many cases, your lordship, I have given a bunch of cases. In all the cases, it has been directed to show the bona fide. Your lordship, the petitioner is to deposit 20%.
Your lordship directed stay,
There is no virus. There is no virus. That is a contravention. That is in contravention to section 62(c). These are the constitutional validity.
Correct.
Your lordship may kindly look into the paragraph.
Here,
3.
Your lordship have understood the case. The thing is, I have paid the tax. I have disclosed my return, and I have also reflection of in 2A. Despite of my paying tax, filing return, and reflecting in 2A, the supplier has not paid. And your lordship have, on the last occasion before...
You have claimed the input tax credit.
Correct.
And this has to be reversed. The moment it has to be reversed, then this component has to be paid.
Here, your lordship have...
that is to be paid.
Your lordship, all these matters have been tagged in that matter. Your lordship may kindly look into the second page.
Your lordship have section 86 and also section 46. Just a minute. Section 76 and 46. That says that revenue, I don't understand. Revenue is coupled, has adequate power to enforce realization from the supplier mirrors. And if they will not pay...
That is what you raise. Raise the issue that they can issue a show cause, they can go against him. But the bottom line of the story is, if somebody has not paid, the action they have to take, whether they will permit you to have the input tax credit. That's the only question. Whether they will take an action against him or will not take an action.
Normally, in
the situation would be more difficult in the event they took recourse to section 46 and 76 of the Act. And then then he deposits, then whether the credit, which is now reversed, can it go back retrospective date or from a prospective assessment year?
Because here what has happened, that's very important to note.
The prejudice and the sufferance for which who will be responsible?
Correct. Absolutely correct. And here, my lords, supplier has already assessed, my lords. My lord, the officers of my friend department, they have assessed.
Your lordship, my Lord and Senior's client, my Lord and Senior supplier has gone to NCLT and has passed the order, and now there is a revenue loss.
Those are different things.
These are the facts, admitted facts.
My supplier has already assessed.
Yes.
Annex 4, if your lordship will find, my lord.
Is first
normally
application for amendment.
validity.
Sorry, my lord.
Application for amendment. 294.
Notice under section 74, the petitioner challenged. The petitioner has come up before this court in the writ application. However, during
challenging the constitutional
notice 6 and
here also, yes.
yes, yes, sir. First notice.
Yes.
Then
Correct.
first one to know during the pendency of this assessment has been passed by the assessing authority. Therefore, the petitioner has filed IA number 2942.
Yes.
Of 2025, seeking amendment of the reproduction. 43. Mr. Mr. All Mr. Both Mr.
I am appearing for opposite but number 1.
Have no objection for
I'm for the balance.
allowing the amendment. In addition to challenge made to the show cause notice, the petitioner challenges as assessment as well as the validity of provisions contained in section 16 to C
Of
bracket small c of the
Odisha Service Tax, Goods and Service Tax Act 2017.
Stroke Central Goods and Services Tax Act 2007. The amendments allowed. Amendment petition is allowed. Let the consolidated petition be filed within 7 days, 7 working days. Adequate numbers of copies to be served on respective parties. जो मैंने सब आपको है ना? Thereafter, you have already filed.
I have filed the counter. Now, as
So
per
now
the
you have to
amendment,
file the amended portion.
Your lordship, within 2 weeks, I'll file.
Additional counter affidavit.
Your lordship.
We file. Since Sunil Misra and standing counsel for the Odisha GST organization has stated to have filed counter affidavit.
Yeah, I have also filed the counter.
You have also?
Yes.
Mr. Sunil Misra may file additional counter affidavit if any. As an interim measure, you have 20%.
20% of the amount reversed.
Lords, already had annexed 4 petition, my supplier has already assessed, my lords. So this will lead to double recovery, my lords.
So, lordship, all these repetition may be tagged to that.
So I am not pressing that may be there. Yes. Let that be there. But only thing is that 20% your lordship is always consistent in passing.
My brother will take care of that. Don't worry.
Same order may come. My humble request because this honorable bench I have never seen different orders are passed.
But I was party to the earlier bench.
Earlier bench true. But the effect with all prudence.
And your lordship might have remembered, my lord Honorable Justice Jaswant Sinha's and subsequent Honorable Chief Justice Muralidhar's view is that that once without going to alternative remedy, you have approached the Honorable High Court.
My brother will take care of that.
All approach him. How can
next matter?
Item 15, sir.
How can my friend have objection to this? All are approaching.
Objecting, I'm I'm submitting, how can I object?
I don't think consent will ever permit one to, after paying again to.
Yes, where is the impugned order dated 21/4? Annexure 1.
My lord.
Yes. Oh, this is a condonation application.
My lords,
How much there's delay?
my lords, earlier, the writ appeals were dismissed on the ground of delay.
Now the
before.
apex court has
my lord.
condoned the delay.
Yes, my lords.
So we have to hear out the application for on merit.
Yes, my lords.
Not application is already disposed of.
My lord.
So main matter.
Main
My
matter, my lords.
My lord, may I please, my lord? My lord, I am appearing in the item number 3, sub-item number 3, your lordship.
What about the others?
I'm not sure how similar are they. I am appearing for
My lords,
third.
notice has to go in all.
You are
the
appearing in Hara Prasad Ray matter.
No, Santanu Kumar. Third sub-item. My lord.
Then who is appearing in other matters?
My lords, no one's name is reflected, my lords. Notice has to go in this matter, my lords. In other matters.
No, there are this Trilochan Raut, or you know?
No, my lords.
Devendra Nath Mishra, you are not.
Santanu.
Rekha Nayak, you are not.
No.
You are in Santanu Kumar Swami.
Item number 2, sub-item number 2, madam. Devendra Mishra, I have received instruction to appear, madam.
Which one?
Item number 2, madam.
Name of
Devendra.
Devendra. So Devendra, you are appearing.
Right.
So Trilochan, the notice has to go.
Yes, my lords.
And
My lord-
Rekha Nayak, the notice has to go.
Yes, my lords. And my Ashok
And
Kumar Patra.
Ashok Kumar Patra,
Patra, notice has to go.
notice has to go. Condonation in all the matters have been done?
Yes, my lords.
All
Yes, my lords.
by the Supreme Court?
Yes, my lords. May I?
Yes, the esteemed apex court has condoned the delay. And my lord, if my lord allows, I may place the case for 30 seconds. It would be over at least. I don't
We
know.
appreciate it, but so far as the others are concerned,
My lord.
they are to be not.
My lord.
They have to be given a notice. So that if condonation was dismissed.
My lord.
Of the state,
My lord.
we have to issue notice. You have received the memo of appeal.
I have.
You have also
No, I'm not received. Copy.
received. Right.
Like all the aforesaid matters have been tagged together, involving the similar and identical points of law.
My lord, not all are similar.
Points of law.
Not all are similar.
Otherwise, why it is tagged together? Points of
Only,
law.
only on delay.
Wherein some of the respondents are represented before us and the others are not. Though the council, what's a good name, sir?
Dr. Binod Mishra, my lord.
Though Dr. Binod Mishra,
Devendra Mishra, madam. Same. Devendra Mishra.
no.
His name is
What
also
is his
same.
name? Devendra Mishra and Mr. Devendra Mishra appearing for the respondent in
WA number 3225.
appearing for the respondent in WA
225.
3222 of 2023 and 3225 of 2023. Objects on the proposition of the common points having involved in the instant appeals, but since all the matters are tagged together, to be decided analogously. We therefore direct the notice of an appeal to be given to the respondent in WA 2854 of 2023, 3223 of 2023, and 35 of 2024.
My lord, also,
The aforesaid, the notices were issued for the reason that an application for condonation of delay filed by the appellant in aforementioned matters were initially rejected by this court, which was assailed by the appellant before the apex court. Give those SLP numbers. Stop. The apex court interfered with the order and allowed the application for condonation of delay with the express direction that all the points required to be adjudicated in the instant appeal are kept open, except the aspect of delay which had already been condoned. Stop. In view of the above, the requisite be filed within 3 days from date. All the aforesaid writ appeals would be listed. After 2 weeks,
Copy may be served on copies.
May I please, my lord? My lord, I have already prepared the objections. If your lordship allows, I'll file it.
come on that day, give it.
Fine.
Yes.
my lords,
Obliged.
my lords, all notice has to go also in writ appeal number 3223 of 2023.
I have already said.
My lords,
I have already said, so far as the Santanu Kumar Swine,
Madam.
he is already appearing, no notice is required.
and Devendra Kumar.
And Devendra, no notice is required. Rest you gave a no. That we have already said.
Obliged, my lord.
You have to only serve copies.
Yes, ma'am.
That is what is required here. Keep it. What is this?
Earlier.
Item 16.
My lords, there is a delay of 526 days.
Sir, 526 days delay. What do you want?
My lord, lordship, the explanation lordship will say the up to 13th and 23rd is some lame excuse there, but they have filed it 1 year after. So there is absolutely no explanation, and the poor doctor is suffering. Not
Would you like to file your counter?
I have already filed my counter.
Oh, you have already.
I have filed my objection. Lordship will see to the
Which
case.
which application is the condonation one?
Application number 2104 of 2024.
And similar case, similar
Give us 1 minute time. Let
Sorry,
us
sorry,
hurriedly
sorry.
go through the
Extremely,
application.
extremely sorry.
What you have done, madam? Can we reconcile the sufficient cause between paragraph 5 and 6? I can understand up to paragraph 4, you have a genuine explanation. But what about 5 and 6?
And
Such a long delay you have not explained. Why the law, what is this?
The opinion.
Law department. Why he sat over the matter for such a long time?
And
First thing is from 20th of October 2022 till 19th of December 2022, no explanation for nearly 2 months. Then 6 from 19/12 to 2022 to 2nd June 2023, no explanation. Why the papers could not be collated? Why the papers could not be given to you for such a long time?
Well, it's
You must have passed on all the papers to the law department to form an opinion whether it requires
whether challenge is required.
challenge this order. What? Why? There is no explanation.
And interestingly, on 13/6/2023, the government advocate got the papers on 13/6/2023 and filed, appeal was filed on 18/4/24, 8 months after. No explanation at all. The appeal was filed on 18/4/24.
No. 13/6 I can understand. From 2/6 to
8
13/6 there is some internal
8
problem.
months.
But from at least from 19/12 to 2/6 there is no explanation.
If you for 13/6
2010, 2022 to 19/12/2022.
No explanation.
No explanation.
And then from 19/12 to 2/6 no explanation.
It's after the opinion was obtained thereafter.
That opinion was given on
1912.
So thereafter
So, well-
nothing. Why the documents could not be collated, and it took near about nearly 6 months.
Have you identified those officials where it was lying?
Well,
Have you
it's-
taken any steps against them?
Well, let's have to take instructions to that effect, my
So
lord.
had that been a
What to do? madam?
reason, it would have been plausible for us to consider.
Well, let's say
We could have appreciated that the file was misplaced in another department. There was a correspondence which was going on between two departments to collate the documents. That was not furnished. All these things I can understand that but nothing. There is a very silent. And this is against an interim order or final order?
Final
No,
order.
final order.
Final. Oh.
Delay of 459 days also, Lordship, kindly I have given on the order of the Honorable Supreme Court from this High Court, my lord. 459 days was not condoned. With
Length is not.
Yes, that is, I
It is
understand.
the sufficiency of the cause which is more important
Yes,
for
yes,
us.
yes, my lord. And
But there is a absolutely scanty explanation for this.
the file came to the Lord's Additional Government Advocate on 13/6/23. A writ appeal was filed 8 months after. After para 6, there is no. The file came to 13.
And judgment, my lord.
Was
That also I can.
We have gone through my judgment, which in a division bench I have passed,
Oh, my lords, I'll go through it, my lords.
dismissing it. For sufficient cause, what is reasonable cause, what is sufficient cause, I have explained.
Only relying upon bureaucratic delay, my lord.
how this helps you?
My lords, para
It
7.
was an shelter which was taken under section 14 of the limitation.
My lords, I understand only aspect.
Moving before a wrong forum
Yes, my lords.
and thereafter, that's the sufficient ground. Here it is not a ground of moving our wrong forum.
Only para 7, my lords, bureaucratic delay, which is what I was trying to stress upon, my lords.
Judgment is to be understood in the context in which it is pronounced. Only underlying 2 words, sufficient cause.
My lord, also recent judgment, sufficient cause has to be explained.
And under Odisha High Court rules, it is good.
My lord,
Give me a latest judgment against this.
My lord, I do
That
not
the
know.
court will not look into the merit. Give us a latest judgment of Justice Mittal and then Justice Padiwala, both.
Justice Partiwal and Justice.
Give the latest of 2024 judgment.
2024 judgment I have not got.
I brought a judgment of Shivraj Singh.
Subbareddy case.
Shivraj Singh is a different.
Shivraj Singh, of course, that case, their case, the Honorable Supreme Court has said that it is the further distinction between should be drawn between inordinate unexplained delay and explained delay, where in the present case, the first respondent has sufficiently explained the delay on account of negligence on part of the government function, the government counsel on record before the reference court. And also it is upon the court to consider sufficiency the cost shown for the delay and still length of delay is not always the decisive factor. And but
My
you
lords, in
kindly
this
see that judgment. Of course, I am
they
sorry that
looked
judgment.
at para 40 and 41.
What?
where This judgment which my learned senior is referring to at para 40 and 41, Shivraj Singh, relying upon this quoting Raj only, they have relied upon this judgment to condone the delay in this matter, my lords, in the facts of that case.
And I have given
Shivraj Singh's judgment has not been considered in your this 2019 judgment.
no.
Justice Pankaj Mittal has relied upon. He says that there should be a harmony between Section 3 and Section 5 of the Limitation Act. Section 3 cannot be undermined, nor should be rendered nauseous by taking a very liberal view in Section 5 of the Limitation Act. So the balance is required to be made in between them. And if there is no sufficient explanation, then it's not an obligation of the court to.
I'm conscious about this.
And the merit should not be taken into consideration. Here it says that the meritorious matters should be decided on. But this is a 3-judge bench decision, sir.
Yes, my lord.
What to do?
That is a
And that is a 2-judge bench.
But Your Lordship, kindly look at that judgment. 459 days delay was not condoned by this Honorable Court, and Honorable Supreme Court confirmed it, said that no, it cannot be. I have given the judgment, my lord.
Pathapati Subbareddy.
Sure.
Pathapati Subbareddy 2024.
That unfortunately I have not got that judgment, my lord. I am extremely sorry for that.
My lord is referring.
Yes, my lord is referring to that, but unfortunately I have not got that judgment. But that I am sorry for that. But,
2024 4 SCR.
Yes.
241.
Let's look at that.
2024 INSC 286. INSC neutral citation. 2024 INSC 286.
You should carefully draft. It should not be a casual exercise, madam. Section 5 is a most responsible duty cast upon the lawyer while he drafts. He should take all the minute instructions from the deponent and the client, and then draft. Admittedly, there is a delay of how many days?
500.
526 days.
526
days in preferring the instant appeal.
It is 498 days delay, which is shown by the stamp report.
490. 490.
495 seconds. 5. Correct.
Delays in preferring the instant appeal against the judgment dated 11/10/2022, passed in WP within bracket OAC number 3172 of 2018. At the time of moving the instant appeal, instant application, an opportunity was given to the contesting respondent to file counter affidavit, which in fact has been filed in the instant case. Before we proceed to go into the nitty-gritty of the averments made in the instant application for condonation of delay in pursuit of ascertaining whether a sufficient cause is made out, it would be apposite to recapitulate the law in relation to an exercise of power by the court while condoning the delay. Next paragraph. It admits no ambiguity that Section 5 of the Limitation Act bestowed power upon the court to condone the delay in preferring an appeal, review, applications for which the limitation period is provided. Subject, however, to recording satisfaction on the existence of a sufficient cause, which is of paramount consideration. There are catena of decisions rendered by the different courts, including the High Court, that the length of delay is immaterial. Semicolon. What is sine qua non is the sufficiency of cause. Stop. The delay of a shorter period may not deserve to be condoned in absence of any sufficient cause shown in the application, whereas the delay of longer period may be condoned if the court is satisfied circumstances which necessitated delay in filing the appeal was beyond the control of the litigant. We are not unmindful of the fact that there has been several judgments condoning the delay of a longer period. Yet there are catena of decisions where delay of a shorter period was not condoned. Stop. The judgment, now in order to cull out the ratio of the judgment, it is an ardent duty of the court to consider the facts involved therein, as the ratio cannot be dissected from the context in which the law has been decided. Stop. A little difference in fact or an additional fact may invite a diametrically opposite decision, and therefore it is imperative on the court, while relying on a decision rendered on the point, to find the parity of facts or the special facts emanating therefrom. Stop. The judgment of the Apex Court rendered in State of Manipur and others versus quoting Lamkang, reported in 2019, volume 10, SSC 408, relied upon by the appellant for the proposition that the court should avoid the injustice to be perpetrated upon the upon the state's interests and may condone the delay by balancing the rights of the parties upon imposition of costs. In the said report, there was a delay of 312 days in preferring the regular appeal. Against a decree passed for eviction of the Director General of Police and the Commandant of 8th Battalion of the Manipur Rifles in respect of the property, which was situated in an area of strategic importance. The appellant therein approached the wrong forum and invested 44 days in pursuing the same, which was also taken into consideration by the apex court in bringing within the ambit of a sufficient cause appearing under Section 5 of the Limitation Act. On the conspectus of the facts emerged from the said report, the apex court taking into account that the property is situated in a area of strategic importance, in the event the right of appeal is denied on the anvil of limitation, it has a larger impact. Stop. Precisely for such reason, the court allowed the application for condonation solely on the grounds that the property having situated in a strategically sensitive area involving the security of the country at large, which would be evident from the following observations. Quote paragraph 10 of the said judgment. It is no longer a centigrade that the court, while considering whether a case of such nature is made out, which would come within the ambit of the expression within court sufficient cause, taking into account the other relevant factors, including the larger impact that would cause on the large section of the society, the discretion may be exercised in condoning the delay. The sufficiency of the cause cannot be squeezed within the straitjacket formula, nor should be used as a Euclid's theorem, but depends upon the nature of the explanation so offered and a satisfaction of the court in constituting the sufficiency of cause. In a recent judgment rendered by the apex court in
Pathapati Subbareddy. PATHPUTI. Pathapati Subbareddy versus Special Deputy Commissioner, Collector, 2020.
Within bracket A.
SCR 241, equivalent citation 2024 INSC 286.
The apex court highlighted the importance of Section 3 of the Limitation Act in juxtaposition with the provisions contained under Section 5 of the limitation of the said Act. It is highlighted that in order to take a decision under Section 5 of the said Act, the court must also bear in mind the necessity of incorporating Section 3 thereof. The apex court held that both the sections has to be, both the sections should be harmonized in order to operate in tandem, and none of the aforesaid provisions should be permitted to override the core object of each other. The moment there is a delay in filing an appeal, Section 3 of the Limitation Act is immediately attracted. Although the power is conferred upon the court to condone the delay, by invoking the powers enshrined in Section 5 of the said Act, subject, however, to the sufficiency of the cause duly shown in the application by the appellant. The enlightening observations from the above report is quoted as under where 1, 2, 3, 4, 5, 6.
Paragraph 26.
Paragraph 26. Quote that. It is not hard and fast rule that the court should look into the merit at the time of considering an application for condonation of delay, as the meritorious matter should not be nipped in the bud at the anvil of the Limitation Act. Stop. Any such consideration would not only offense the provisions contained under Section 3 of the Limitation Act, but would also impliedly overridden by Section 5 of the Limitation Act. The canon of interpretation of the statutory provisions does not permit any provision of the Act to be submerged by the other provisions, but all the provisions have to be interpreted in a harmonious manner to render it workable rather than to make it osseous or redundant. It is a duty of the court to harmonize different underlines such incorporation. And the interpretation which would frustrate such core intention should be avoided. Stop. Now, keeping in mind the aforesaid broad principles of law, from the aforesaid the reports, the aforementioned reports, let us examine from the pleadings made in the said application filed by the appellant whether any case of sufficient cause is made out. The application for condonation proceeds simpliciter in its opening paragraph that the said appeal is filed against the judgment dated 11/10/2022 passed by the single bench in WP within bracket OAC number 3172 of 2018. Stop. Thereafter, it is pleaded that the copy of the said judgment was received by the department on 14/10/2022 from the office of the Learned Advocate General, Odisha. And after the perusal of the order, the deponent of the said application was of the view that the said judgment dated 11/10/2022 needs some clarification and caused a letter dated 20th October 2022 to the Law Department for forming an opinion in this regard. In paragraph 5 of the said application, it is stated that the Law Department, with a letter dated 19/12/2022, communicated the decision of challenging the said judgment dated 11/10/2022 before this court, before the division bench. But interestingly, despite the opinion expressed by the Law Department to prefer an appeal, the deponent of the said application could collect all the relevant documents and forwarded the same in the office of the Learned Advocate General on 2/6/20. Look, what emerged from the aforesaid pleading is that though the deponent, after perusal of the impugned judgment, was of the view that some clarification is required, and immediately forwarded the same to the law department for taking an opinion, there has been a considerable delay of nearly 2 months in the office of the Law Department to take a decision whether the appeal against the impugned judgment should be filed or not. There is a complete lack of any explanation for the delay of 2 months. In the said application, demanded by a person who has a legal expertise or a knowledge of law, and it is inconceivable and improbable that 2 months period would be consumed to form an opinion when the period of limitation for preferring an appeal is well within the knowledge of of such person having a legal acumen. Interestingly, after the opinion was expressed, yet more than 6 months were consumed from collating the papers and forwarding the same to the office of the Learned Advocate General to prefer an appeal. It is not a case that the appellant did not contest the writ petitions before the single bench. And was therefore well aware of the stands taken by the respondent as well as the appellant before the single bench. Since there is no responsibility fixed upon the officers manning the different departments in the government. The casual way of dealing the matter is evident and apparent from the aforesaid pleading. Despite the fact that the state has felt take away the applicability of the law, which puts in fetter in the event there has been a considerable delay, there has been a considerable unexplained delay in preferring an appeal. Since the explanation offered in the instant application is not satisfactory, and there is a carelessness and lethargy attributable to the conduct of the state, we do not think that it satisfies the necessary ingredients of within court sufficient cause for the purpose of condonation of delay. The application is thus dismissed. Much obliged. Read also. No cost. Yes.
Item 17.
My lords, item 17, there is a delay of 623 days, my lords.
Yes, sir.
Here I am appearing for the respondent, my lord. If your lordship will kindly turn to paragraph 4 and 5 of their application. They have tried to
Would you
explain.
like to file counter?
No, counter may not be required, my lord, because if your lordship will kindly, the bona fide.
Application 3.5.
3547.
No, no. How would it be? Oh.
Don't suffer today.
Blood.
Don't suffer today.
My lords, only reason is that it was.
No, don't take it to yourself.
Already, so far, this
Already-
is concerned,
Regarding file, the chief secretary was reviewing the matter where appeal is to file.
So you should have, instead of young counsel.
Yes, yes, there, that's what I am going through.
Yes.
Even beyond the previous order, I was examining in this case what.
So you have heard in the first hour,
That
the
previous,
tenor of the
Previous
judgment,
case.
my lord has dictated.
Previous order.
The
And-
same.
and here if your lordship will.
4. Look at paragraph 4. I am not going very rigidly on paragraph 5. I am very liberal on paragraph 5.
Because that was a delay from.
I am very liberal.
Yes.
And here if your lordship will kindly permit me,
It's the blame on that. I can liberal.
here, my lord, if your lordship will kindly permit me, my lord, the judgment.
Four, you have to justify paragraph. 5, I am liberal. I do not want that any responsibility should come on your shoulder. Though there is.
And that too, my lord, here, my lord, what has happened after the impugned order was passed.
That is on
Yes, ma'am.
28, and thereafter the meeting of the chairman was done in the month of
No,
December.
prior to that,
So-
they took a decision to comply the direction.
Between August to December.
Prior to that, my lord, they decided to comply the order. That is, they are with me, my lord, I am filing through an affidavit. Your lordship may kindly have a glance, my lord.
That is in the contempt.
No, my lord, prior to that, if your lordship will kindly turn to annexure 4 here, my lord. They wrote the deputy secretary of to government.
What is this document?
My lord, that document is a letter to the.
Now you
my lord,
are filing objection to this.
no, not
So-
filing
so we
objection.
will-
Only
will
to say
upon the document.
they are bona fide, my lord.
How can it?
Rely upon a document which is not there on record.
But I am just willing to show it to your lordship.
Either show it by way of an affidavit or.
Yes, by way of an affidavit, I have already given them copies since February 2025.
Then you are filing a counter to the.
No, not counter, I am filing an affidavit, my lord.
Mr. To an IA, an affidavit is filed or an objection is filed?
No, affidavit I am filing.
How can we take it on record?
My lord, it is up to your lordship. My lord, I am not insisting very much. My lord, only to bring. Yes.
Yes, madam, the difficulty is today's problem. My brother has already given a lead. What to do?
Mr. Devraj, guide her. You are a seasoned advocate.
Some other days. Lordship, keep it at.
ଗୋଟେ ହେଇଗଲାଣି ଖରାବେଳେ
To extent.
And 2025 decision of the Honorable Apex Court, my lord, your lordship was in that Justice Pariwal, my lord. The decision I have also brought where it is said, my lord, that the sword of Damocles cannot be hanged over the head of a litigant for time immemorial. That is the decision of the Honorable Apex Court, my lord.
Where is the question of democracy comes?
My lord, here, my lord.
Where is the question of democracy comes, sir?
My lord,
We have considered with the condonation of delay in preferring an appeal. How it has got any nexus with the democracy?
my lord, because the period of delay, my lord.
What is this?
My lord, the period of limitation, my lord, 2022 to 24, my lord. 600.
Time may be granted to seek instruction, what was, how the file.
Democracy, my lord.
I try to develop and file a better one. Let's just the request of so that additional we are just adjourning, right? Try better.
Item 18.
Mr. Devraj, kindly assist.
But your lordship may fix up a date so that.
Information and instructions.
Item 17, your lordship. Another identical matter. Interpret 2601 of 2024. That can also be tagged along with this.
What? Why will we tag it?
Because in earlier occasion, when the matter was listed, this matter was listed along with this matter.
This is relating to condonation. This is relating to condonation only.
On 4/3/2025, along with this matter, interpret number 2601 of 2022 was also listed. This time it has been segregated. Therefore, it is this matter also.
Unless we look at the file of both and find that it has to be tagged, why we'll tag it? And when it is detached, then there must be some conscious decision for detachment. So let us see, we'll consider this when the matter will come.
Item 18.
Item 18, I filed my wakalatnama on 8/11/2024. Appearing for the response. My name is not indicated in the cause list.
There's a delay of 110 days.
Yes, it is there. It is there.
Oh, that's now this time I can say that you have
Yes, my lords.
drafted very carefully.
Yes, my lords.
Maybe I'll grant an opportunity to file an objection, your lordship, to the
What?
higher to the
110
condemnation
days
of.
and the explanation is there for each.
The copy also has not been
The
served.
copy, you have, copy. Fix the matter in the next week. It's a small matter.
Online.
Yes. Online. Call the next.
Item 19. Item 19.
Yes. Which one is the condonation application?
IA number 101 of 2025. $350.
I am the respondent.
Yes, what do you say?
Copy of the limitation system.
So,
But as it appears, 354 days delay.
yes.
Item 20.
Madam, this is also the same.
Well, it's
Same problem.
Well, it's file.
Check up. You segregate those files, check up again, come back. Serve copy on Mr. Sanjeev Mahanti, standard advocate who appears for respondent. One. No. Adjourn.
Item 20.
Item 20, my lord, and 166 days delay in filing the appeal. And appeal has been filed after issuance of the contempt notice. This was disposed of on 23rd August 24. Then contempt was filed on 13/12/24.
Nothing.
Contempt notice was issued on 21/1/25. Thereafter, after
Then
issuance of
let us
notice,
consider paragraph 4 again. What is an explanation? From August till February 2025, what? Nothing. September, October, November, December, January. And then the February that came near about 6 months. No explanation.
My lords, if I may submit on merits, my lords, in this matter.
Merit will not do. Have you seen the judgment?
In the first half,
Yes, my lord.
my lord has dictated that referring to Honorable Supreme Court Subba Reddy case,
Yes, my lord.
merits need not be seen.
Yes, my lord.
What to do?
My lords, this order, my lords, my lords, if this matter may be fixed for final hearing on Monday, my lords.
Final hearing with
Along with,
application, you have to pass.
yes, my lords.
If the application goes, then the hearing does not require. Is the farcical exercise.
My lords, then, my lords, if I may refer to one more judgment, my lords.
Honorable
We
single
refer the
judge,
recent judgment.
lords, you honorable single judge are directed to comply the order or
Contempt.
obtain a stay in DW. So that's the, pick the matter on 6th.
Sixth.
So you are pressing your section 5. So let us decide again.
My lords, if I may hand over this order, my lords.
No doubt. Give it. No problem. Use holding for different cases, different judgments.
And also, my lords, if I may refer to the recent judgment passed.
What is this?
My lords, this is the, in this matter, my lords, contempt proceeding has been initiated and the matter is
What
picked up.
can be done, madam? First, you have to pass the hurdle of section 5. I'm on that. Have you seen paragraph 4?
Yes, my lords.
So what? Can you justify it? Is there any explanation?
My lords, if some time, till time may be granted till Monday for filing a better affidavit.
Whatever. Yes.
Very strong words have been used by Honorable Single Bench. Maybe on merit, I'm not on merit, but very strong words.
Yes.
Your lethargic attitude has been depicted in the order itself.
Let's call the next. We give him 6.
Address 6.
6.
6.
Item 21.
There is a delay of 95
Have you
days.
served the notice? On
No
the-
notice has not been issued. A corporation
Yes.
notice has to go.
You serve the notice?
Mine.
Yes. On section 5.
Three working days. Aye. Notice and aye.
Call the next.
Item 22.
The 22, the
Please, your lordships.
Please delay, sir.
21 days.
Yes,
Non-filing of
41
postal
days.
requisites, sir.
My lord, in fact, my lord, the delay of 41 days.
Postal requisites.
No,
Non-filing of
requisite
postal
for- but
requisites.
requisite in filing late. That means the accepted postal filing late, that received with me.
Office
Requisite,
notes shows notice to respondents on
No, no,
question
that
of late
filing
basis.
late.
Fine, deleted.
But our personal copy service received with us.
Anybody is appearing for the other side?
No.
Then requisites have to be filed. There was a direction.
The notice has already been filed in late, that may be accepted.
Requisites was directed to be put.
Sir, have you complied with?
Yes, they received.
Order dated 24/4/2025.
Requisite.
When?
Requisite filed today also.
Requisite
That
filed today in compliance of order dated 24/4/2025 to be accepted and the office to proceed.
Well, that is
No, approved.
Yes, call the next.
Item 23.
Short date.
Item number 23.
Who?
The conducting counsel for the applicant, or should we specify out of station and pay for an implement?
Stay have you vacated?
He is opposing the prayer.
I am for the respondent.
He is opposing the prayer. Convince him.
Challenge the order of the single.
You are for the, he is appearing for the appellant.
I am for the respondent.
Oh.
Declared as
You
selected. case.
don't have the brief for OPSC. Tarun Patnaik is the counsel for Odisha Public Service Commission.
Somebody else, Mr. L.
So you are
VP Tripathi.
He is not available in the city, out of station.
Next week. 5 years has been already complete. 5 years already gone.
Mr. Tarun Patnaik for the appeal. It is stated by son.
What's the good name?
Adyasha.
Adyasha?
Adyasha Kara. On behalf of Tarun Patnaik. The council is not available today. This matter. She prays for adjournment. She prays for adjournment on behalf of Mr. Tarun Patnaik. For appeal. After that,
Next week.
21.
Next week. Item 24. Well, that is.
Interim orders was there.
Contempt in your.
Will be next week. Anything of the. Six and. Nice, senior, again, council.
May I please?
24.
May I please, your lordship? And this, your lordship will consider this is a matter where by order dated 10/9/2024, this noble court was pleased to direct that the matter will be listed in top 5 cases. Thereafter, this noble court was again pleased to direct that the matter should be listed in a bench which is well conversant with Odia with the permission of the Honorable Chief Justice. And thereafter, by virtue of the administrative order of the Honorable Chief Justice, the matter has come up today on my mention.
That was not communicated. So let me recuse the bench
No, my lord,
where they can understand.
My lord, it is there.
Documents.
Honorable Justice money is there. My lord, if your lordship permits, I will assist your lordship.
But that will be a single bench consideration.
No, a single bench order is being challenged in writ appeal.
When you say something, that means that would tantamount to a single bench.
I couldn't. No, my lord, not that way, my lord. My intention was never like that, my lord. What I humbly beg to submit that this matter has come on my mention. I beg to place it because concurrent finding of the courts below has been reversed by the Honorable Single Judge, and your lordship will find here the issue is with regard to whether the respondent is able to read and write Oriya, that much. And your lordship will see whether the judgment of the Honorable Single Judge reversing those concurrent findings is sustainable in law or not.
Mr. Misra, what my lord has said, you didn't get it.
Got it, my lord. The lordship is there, my lord, can we decide?
My lord says, if you address such an aspect, it will be addressing to single bench, not the division bench. That way.
Now here, without referring to those ODI documents, possibly it will be difficult to appreciate whether he has been able to read and write ODI.
Translated copy at least. Translated copy is
Translated, it will not be because a translated copy, the only difficulty would be that for appreciating your lordship will consider whether that sentence he has written is actually having any coherent at all relating to meaning of the thing that was written and given to him or her to write. But because she has to read and write ODI in order to be eligible to be a sarpanch. So here your lordship will only see the exhibit. It shows that she is absolutely unable
That
to
is
read.
also a difficulty with me, these two. Neither can read nor write, but understanding, yes, to some extent.
The only saving grace is my lord Justice Raman is there, my lord. The lordship for the second place.
Whatever is written, nobody can understand. That is what you are.
My lord, your lordship may kindly
It is
see.
not Odia. Only some alphabets have been written in Odia, but that doesn't reflect any meaning.
And that is the writing part of it. So far as reading is concerned, the learned trial court during cross-examination has specifically observed that except identifying certain letters, he is not able to read any sentence at all. That's a factual finding. So it has to be both reading and writing. So he has been able to write something which is not coherent. Nobody can understand. But so far the reading part is concerned, specific observation of the learned trial court is that except identifying, your lordship will kindly see page 24.
It's a election petition.
Yes, your lordship.
What is the eligibility criteria? What is there?
There is, my lord, your lordship will see he must be able to read and write Odia.
Where it says?
That is, your lordship will kindly
This
see.
is the election of what? Which post?
Sarpanch.
Sarpanch.
My.
Before some other bench, your lordship.
Seen.
Arguing before some other bench, your lordship.
In the corridor, he.
Okay.
While coming back from.
A short passing granted, your lordship.
We have seen him in the corridor.
Your Lordship, several can be granted.
That itself shows your conduct.
I had a similar experience there also. There are no difficulties.
He must be there. Just open that door, he will be there. I'm sure he will.
And,
Senior is arguing there.
Which item number?
Also, we
He is there.
I must be very honest.
You may accommodate Mr. Misra.
To this noble court, who was arguing a matter, I don't know whether it is
No,
over.
Mr. Please accommodate.
Tomorrow, yes, tomorrow.
Your Lordship.
Yes.
Yes, Your
Tomorrow
Lordship.
we have
Tomorrow.
court.
Yes.
Tomorrow we have court.
Yes.
Yes, Lordship.
At the request of Mrs. on behalf of force. Mr. Samir M.S.RAMAN.
S.R. Behera, madam. S.R. Behera. Sachiranjan Behera, madam.
Sachiranjan.
Sachiranjan.
क्या पूरा ना कहे असुविधा होची?
No, no, madam.
Item number 25.
I don't it's a matter related to real estate. Lord and AG wanted to argue this matter today. But today the rehabilitation matter is fixed in the apex court yesterday has got. So let it come after vacation.
What matter?
Real estate law has been challenged.
Yeah.
What matter is there? Fixed there.
That is rehabilitation matter at Supreme Court AG. That today. Let it come after vacation.
Rehabilitation of
My lord?
rehabilitation?
Rehabilitation matter is fixed in Supreme.
Rehabilitation assistance?
Yes.
तो अपना सारी सालेनी मुआजी सारी सालेनी. We have already concluded. You have amended
Those
the
are
law.
pending matters there.
You have amended the law.
Yes, yes, those are to be disposed of today. In light of the amendment, those are to dispose of today. Yes, not some other connected.
500 matter pending.
Yes.
500 matters are pending. Let it come after vacation.
Come on, sir.
Yes, what do you say?
Yes, my lord. I'll accommodate, my lord.
Mohita.
25th June.
Next.
I pray only the interim order may continue, 12th of February 2020.
Lordship, I'm for the intervener in IN number 2541. My presence may kindly be.
Let that intervener's application, we also take it up.
Item 26.
Please, your lord.
What only, sir?
This.
My lord, in this case, there is allegation that the quarry operation is going, crusher unit is having its operation in the school premises. That is not correct. We have already filed our petition. And school is located at a distance of 2.5 kilometers from the unit. So collector has given also no objection. And your lordship probably had fixed date for the filing affidavit in pollution board.
In fact, if your lordship permit me, this it's non-adversarial petition. If your lordship kindly have a glance over our prayer, it's very specific that the person who has got the NOC should be allowed to operate only on the permitted land, not beyond that. That is, for the moment, I am just referring 317 by 754. Now, the NOC is at page 34, which is in accordance with a sitting criteria for which, following which the NOC is being granted for the stone crusher unit. It also reflects plot number 317, 754, page 34.
Yes.
Now, if your lordship will come to the counter affidavit filed by the state, my lord, they have categorically admitted page 2, paragraph 6. May I read, my lord? Page 2 of their counter affidavit, paragraph 6.
And then additional plot number 307,
Yes,
313,
he is
14
operating
and 15.
other than the permitted plot.
They are used partially.
My lord, that is their specific stand.
And has obtained a consent to establish.
And the NOC.
If the permission is restricted to a plot number 317 by 754, how can they can utilize and use the plot number 307, 313 to 350?
So far the other plots are concerned, those are private plots, and that owner has
anybody
taken that on lease.
For what he is using?
Stone crusher unit.
And the no objection. So far other plots are concerned, he has purchased from the owners.
Correct.
And in respect of those plots, so collector has also given the permission.
Where it does not say so. Your contention is that further 7 has obtained consent to establish. What? Establish in this plots.
That is how your lordship has asked why you have only imposed 1 lakh cost at and how it is permitted to impose cost for operating on the land other than the other than the allowed.
Only those are agricultural land, those are not converted. So Tahsildar imposed penalty on account of that, my lord.
Imposition of penalty.
No, Mr. Counsel, I do not know. Let me understand the thing. For running a crusher,
yes,
I think the mandate of law says that the permission has to be granted.
Yes.
The permission is to run the crusher at a designated plot.
Yes, my lord.
Nobody can operate a crusher in any other plot, be it his owned plot or be it a leased plot or be it anybody's plot. Without any permission, nobody can run. Then how they are running, even if they are the owner of 307, 313, 14, we are not entering into. Let us proceed that they are the owner.
Yes, ma'am.
Can they operate crusher from there if the permission is mandatory?
So far those plots are concerned, they have taken permission, that is what saying. I want to explain.
Show us that there is a permission, no problem. We can throw them out.
Explaining that aspect, my lord, will file an additional affidavit. What query your lordship is making?
No. Because there is an ambiguity that comes in paragraph 4.
Oh.
If you look that the averments, no, not in paragraph 6. That in reply to the averments made in paragraph 3 of the writ petition, it is humbly submitted that the crusher unit is functioning over plot number 317 by 754. No problem, because he is also admitting he can.
Yes.
Such and such. And then you say plot number 307, 313, 14 and 15 are being used partially. That means apart from this, 307 is also used. Then further, the opposite party number 7 has obtained consent to establishment. Now I just wanted, what is this consent to establishment?
That is at page 8 of that very affidavit. State Pollution Control Board's.
In respect of this plot number 307?
No, my lord. It is only 317 by 750.
No problem. You have no grievance against that plot?
No, my lord. He has got.
Show us that they have.
I think this forest and environment order. 2010.
explaining that.
Take an instruction. If there is a permission, show us that there is a permission or license granted.
Yes.
If it is not, then it is your responsibility to stop. That's the law.
I will file an explanatory affidavit, my lord.
Counter affidavit. One more subject. to
What
your law.
more?
The nota bene says, nota bene of the permission for establishing the crusher unit says, this NOC will be revoked, withdrawn for violation of any extent of rules, guidelines.
That is not your case. Don't say. Your writ petition is let him operate from 307.
My lord,
Don't go for
non-adversarial, that's why I have said, my lord. We are
Don't
not
go for
taking-
cancellation. Let us see whether any permission is granted to 307, 313, 14 and 15.
Yes, ma'am.
The counter affidavit, the attention of this court was drawn to a counter affidavit filed by the opposite parties number 4 and 5. Wherein they have indicated that the crusher unit is functioning over the plot number 317/754 of Mauja, Chenagaon, and the plot numbers 307, 313, 314 and 315 are being used partially. Though it is said that, though it is stated that the opposite party number 7 has obtained consent to establishment within bracket CTE with a letter number 2730 dated 16/7/2022 issued by the State Pollution Control Board of Orissa at Rayagada, and consent to operate with a letter number 2800 dated 21/7/2022 of the State Pollution Control Board of Orissa at Rayagada, but it does not specify whether the same was issued in respect of the other plots than plot number 317/754.
Para 3 of my counter, there is explanation, my lord. That is only other plots are used only for purpose of stacking material and all that. But operation is going on 317/1.
But what about this partially used? Functioning.
That will go.
Your language is, you have combined both 317 with 307.
Yes, my lord.
So that creates a confusion. Stop. On being, so like, a query was raised whether any permission or a license is granted for the crusher unit in respect of the aforementioned plot. Which are used partially, the council for the state submits that they may be given an opportunity to file additional affidavit to disclose the better particulars in this regard. Let additional affidavit be filed within
1 week.
1 week from date. List the matter accordingly.
Yes. Item 27.
Lord, I am on Vishi. Lord, I am on Vishi, madam. Am I audible to my lords?
Yes, sir.
Matter was on my lord's board, if your lordship would kindly see, on 8th of April 2025.
8th?
8th of April.
My lord, your lord.
Yes.
Lordship will see the order, sought order passed by my lord. That is with regard to whether the petitioner has lifted the quantity for 24-25 within the period or not. Thus, and an additional standing counsel for the state, for the parties submit that though the prayer is couched in a different manner in the instant petition, but in view of the submission advanced by the learned senior counsel for the petitioner, she is required to take necessary instruction.
Lord, instruction has come, file the affidavit, received.
Lord, it's a short question. I am interested to surrender my shop. Look at the order passed by the collector.
Even date of surrender the application, he has to clear all the due. That is what he had not done. Then the collector has also assigned the regime that on the ground of illness, he has wanted to stop the So no certificate was given regarding the illness of the person on loan, so that it not possible for him to operate the. So
Can
this
you
is the ground of instruction I have received.
Can you
compel me to run the shop?
utilize the best potential from a person who is unwilling to work?
Correct, my lord.
You can't force an unwilling person.
But the only
If
condition.
you wanted to go out, you engage another person.
On the date of submission my application for surrender, he has to clear all the dues.
So that is what, no doubt, they have to clear.
I have. Kindly see my page 8 of my IA. Flag
But
B.
the latter will be cleared, not that.
What is it? Now let it consider the latter date. Now, as on this
For
date,
reconsideration, your lord, she may die.
you take a positive instruction now after this development. Now they have already paid up to that from the day when they stopped functioning. Now just take care of that and take a decision. Relieve him, allot somebody that shop. You need a shop there. Allot somebody else.
We asked him for shifting to some other place. It's not good.
Shifting that I do not know. Here
But
I
it's a-
find is a very frequent thing.
Shifting is not allowed. Shifting is very difficult, cumbersome process. Very, very difficult. Very difficult. Another objection sets up objection for that he's not
I
there.
get why the concept of shifting arise. If at the time of granting a license, if all the formalities were already taken care of and complied with, then what is the necessity of shifting? I do not know.
Not required at all. I don't want to run it. I want to surrender. Your Lordship, see section 49. It is as clear as it is. Kindly see section 49. Doesn't require any reason even.
Tuesday, let him come with the instruction if they can. If he already cleared the dues. Tuesday.
Item 28.
Just make them aware that yes, dues they have to take. Mr. Counsel, the dues they have to clear, no doubt.
Yes, Your Lordship, put for a moment, see page 8 of my IA. Kindly see me. Flag B, page 8. For a moment, kindly see.
You know better than anybody what
Lord,
they
I know.
will.
Lord, kindly see page 8 of my IA. Lord, their LPL means London Proof is 70,500.
You do not know what they will. I anticipate something. Let me think. Let me see whether my anticipation is correct or not.
Right.
Let them Tuesday.
Let them come back on Tuesday. Yes.
Yes.
Item now 28.
May I please, Your Lordship? Hearing this, this is a PL matter, my lord, with a prayer that the OP number 2.
Yes.
May I please, Your
Before it
Lordship?
starts, my lord, your lordship may kindly see order date 8/4/2025.
That I have already opened, sir.
My lord, but he has not complied. The only copy of the IN number 5278 of 2025 is served on me.
Why you are not serving, sir? Copy of the brief on Mr. B. Bagh. You are Mr. B. Bagh?
Yes, my lord.
Yes.
Copy already supply, my lord.
Copy received?
Yes, my lord.
What you have supplied?
The Dropbox में
A drop?
Dropbox received in the Dropbox.
I do not know this concept of Dropbox here. What do you mean by Dropbox?
Mr. Counsel, have you read the order dated 8/4/2025?
Yes, ma'am.
Please read that. Please read that.
The order dated 25, lordship be directed to serve the copy, my lord.
8/4/25.
That date, the copy already supplied, my lord. The receipt already filed, my lord.
After 8/4 you have supplied?
Yes, my lord.
Where is the?
No, my lord, only he has served the copy of the IA.
IA copy or read copy already
5278 of 2025, and I have filed the counter there too. But my lord,
What is it?
He has not supplied serve you a copy of the writ petition.
Madam, your lordship may kindly appreciate. I have collected the writ petition after it knowing the fact that it is writ petition is filed. which was published in Delhi newspaper, but I have not collected the annexures. And further, an affidavit is also filed. They have not served a copy of the affidavit also on me.
My lord, the read petition they filed already preliminary counter already filed my lord. Thereafter, I in interim application filed the stay petition. The stay petition already.
Mr. Counsel, please. 8425, the order is Mr. Manoj Mishra. Learned counsel appearing for the petitioners is directed to serve a copy of the brief on Mr. Bansidhar Bhatt, learned senior counsel, who enters appearance for opposite part number 9 in course of the day. Yes. So have you supplied copy of the brief, which he denies that he has not been supplied with the brief. He has been supplied with only IA. IA is not the brief.
No, my lord. Read petition is the brief.
So whether you have supplied or not, please give me the receipt or acknowledgement. Please.
Sorry, my lord, I have to say that.
This is how I understand.
My lord is absolutely correct to that extent. I'm not disputing for that reason because
it's very clear.
If that is so, my lord, they could have produced the receipt showing that I have already solved. But
when he is disputing,
yes, absolutely correct. I am not disputing at all.
When is disputing, that's
yes, correct. When dispute arose, that's
otherwise I would not.
My lord is absolutely correct. When the dispute arose, we have to produce the receipt showing that we have already solved. The matter is solved. But
may I be permitted to intervene, my lord? My lord, there in this case, I have filed an application for intervention. In these petitioners, the interveners, the store
that been admitted, my lord.
because I also came to know from the newspaper publication.
What is this? What is who is for the petition?
I am for the petition, my lord.
Yes, what for you have filed?
I have filed this petition with a prayer that OP number 217 will direct to stop the illegal stone quarry operation against the OP number 9 and 10 of against the OP number 9.
OP number 9 and 10 means
9 and 10. In whom
the operation?
Yes, my lord. In whose favor the quarry is allotted, who they are OP number 9 and 10.
What is the language? I do not know. Why the OP number 2 and 7 will not be directed to stop the illegal stone quarry operation against opposite party number 9
yes,
and 10?
So far, with your lordship's permission to that extent, my lord. So far, the OP number 2 is the collector of Keonjhar and 7 is the Tahsildar. So far, the OP numbers 9 and 7 are the private parties in whose favor the quarry is allotted.
I can understand why opposite party number 2 and 7 will not be
directed,
injuncted or directed to stop the quarry operation in respect of a plot, something against opposite party number 9 and 10. This is going above my head. My little knowledge of the language.
That should not be, but I am not in position.
It should be in respect of land.
My lord is correct, but listen.
So you wanted that they should not operate the quarry operation.
Yes, my lord.
Correct. So
two things I will draw your lordship's attention.
Why you wanted? Why?
Yes. To that extent, two things I want to draw your lordship's attention. For that reason, I want to draw your lordship first of all, Annexure 1 that was allotted, my lord. Then thereafter, at the time of allotment, Annexure 5 is there. So far, the guidelines for environmentally sound operations for stone quarries. Certain guidelines are there. For that reason, I want to lordship's attention page.
So they are not following the guidelines.
Much obliged to that extent.
This is what you wanted to say, that they are not following those guidelines, and they are continuing with this quarry operations.
Yes, ma'am.
Quarry operations, and therefore they should be restrained from operating it.
Much obliged.
Or at best, if they want to operate, they must comply those.
Now, another thing is there to that extent. 5.2 in page 8.
In that case, we want to file counter.
Just with
they have allegation of pollution they have raised and all that, but member secretary said pollution control is opposite part number 4 here. Affidavit from pollution board is necessary, man.
With the lordship's permission, two things I want to do. So far,
State also will file counter.
So far as the guideline is concerned like this, and the report which is submitted Tahsildar will clarify that is contrary to the guidelines. as a result of which.
So have you challenged the guidelines?
No, that report submitted by the Tahsildar.
Yes.
It shows that is contrary to the guidelines that is the government department shows. And that is there.
Have you challenged that report of the guide?
And that is here, my lord. For that reason, I am saying that should not keeping in with the report, all of the things, that should not be allowed. For that reason, we follow.
Stop.
When the report says like this, that is contrary to guidelines.
It's a public interest litigation.
My lord. Admit.
You are not assailing any order.
No.
Simply you have come that now the government is not really taking actions. There has been a lot of problems which is now going on.
Yes, ma'am.
Those have to be taken into consideration. You said that this quarry, if it is permitted, there is a blast and all everything, the dust really goes polluting the air. Polluting the air. There is also noise pollution because of the blast or explosive being used.
Yes.
And therefore, there should be either some check and balances that has to be done if the quarry permit is allowed or granted. This is what you your interest, that there should be some mechanism, there should be something which is to be done. So let us restrict to that.
Yes, madam. For that reason, 5.4.
So let the government come and suggest that what they are doing.
Yes.
If something more is required, and those have not been taken care of, we will definitely say as a PIL.
Yes, ma'am.
Yes, my lord.
My lord, my submission for my.
Para 6 of the petition,
While
para 6 of the petition as page 9, he has given what are the problems they are facing by operation of the quarry and all that.
Yes, ma'am.
Yes.
We will look into that and file our affidavit.
Do it, suggest that.
But
Suggest that.
now Tahsildar can file because it has
I
gone to
don't
the
think
Deputy Director of Mines.
6.1 is required to be dealt with
Yes.
by you. What is this 6 on these grounds? Is this a ground? Without spelling that what is their rights?
So for the 5.4, my lord, that is
6.1.
5.4.
6.1.
That they adversely affect the rights of the villagers and they will suffer like anything.
So these are the grounds
That so far.
in a PIL.
But,
my lord, they are not the villagers. my lord.
Just
They are not the villagers.
Not necessary. Sir, if any person has come and flagged an issue which is a larger interest, then in that
That's my right. I have filed a preliminary counter affidavit, my lord, you also can bear with me.
Even sometimes we can treat this PIL as
Yes,
suo moto
But
PIL.
my submission is, my lord, you also can appreciate.
Is a larger issue, something is to be done.
6.4 they have dealt, how they are suffering. What are the environmental effect requiring?
This is the main. This is the main.
Yes.
Yes, my lord.
Even 6.7.
Yes, ma'am.
6.1.
So let us see, is there any SOP or is there any guidelines which would really
ma'am.
restrict this? Who are you supply?
My lord, I am OP number 9, my lord. I am operating the query. You also can appreciate my.
Sir, you are, I know.
No, my lord, I am not on that
I
point.
know why you are so
My lord, why? Because my lord, they are creating problem because their subscription is not paid, for which 3 FIRs have been lodged against them. Thereafter, the present PIL.
whatever. The counsel for the opposite party number 9 submits that despite the order dated 8/4/2025, the copy of the writ petition with annexures have not been served. Full stop. It is further submitted that the copy of the IA is served, for which the counter affidavit has already been filed. Though we find that the councils are not ad idem on the service of the copy of the writ petition, but in order to bring quittance to such issue. The petitioner is directed to serve the complete copy of the writ petition upon Mr. B. Bagh, the learned advocate who is representing opposite party number 9 in the instant matter. What's your good name?
P.R. Barik, Prakash Ranjan Barik. P.R. Barik.
P.R.
Barik.
Barik.
My lord.
Mr. P.R. Barik, the learned advocate appears and submits that he has filed an application
For intervention.
for application for intervention,
My lord.
being IN number
6750 of 2025.
2025. Mr. Barik is directed to serve the copy of the said applications.
I have served.
Oh,
I have served.
you have got it, sir?
I will serve on the state council.
Yes, ma'am.
Directed to serve the copy of the said application upon the council representing the state. When today?
Tomorrow I will serve.
By tomorrow. It is open to the parties to file response to the said application for intervention. If they think so, before the matter is listed next, put it after 10 days. 7.
Item 29.
I am a pardon to say, my lord, I beg apology for the inconvenience of the court service.
Please, sir, it's over. Why are you raking up?
No, sir.
You have disputed.
29.
Item 29. Your Lordship had asked the government to give its instructions, my lords.
We are from the Union of India, the railway. May I audible, my lord?
Yes.
My lord, is sick. Can it be after vacation? In the meanwhile, we will file the detailed counter because I got the telephone instruction and on the instruction itself said that followed all the procedure. And the Sarpanch is non-equal party. They are alleging as Sarpanch. And the one Sarpanch has given NOC to the railway. And on these details, we will find the detailed counter, my lord. Let's give 2 weeks time.
I may pardon, Lord. But
I am the petitioner. I have to place my case.
Sorry. Yes, please.
Well, it's here.
No, have you seen? He asked for an accommodation.
Yes, my lord. See, if he asks for an accommodation
he wants. That is what he say. The London DSG will ask for an accommodation.
Yes, my lord.
2 weeks time may be given in the meanwhile.
Yes, 2 weeks time.
My lords, I only have a prayer before your lordship.
The period is over, my lord. Annex of
The period is over. Exactly. That is what I'm trying to place before your lordship. The consent is already over. Still then they are coming onto the railway siding and trying to, my lords, load the wagons, which is totally contrary to the consent order itself. If your lordship
for that he wanted a time to take an
my lords, as on date, there is no order existing.
Correct. Either renewing or extending that particular the permission.
My lord, what I'm praying for is that there should be the status quo as on date should be maintained at that spot. Because, my lord,
very dangerous, sir.
My lords, if not status quo, they should not be allowed to continue the loading
I
operations.
request you to read the judgment of the Supreme Court.
No, my lords, I've gone through
Kishore
it.
Khaitan's case.
My lords, I've gone through that judgment. Otherwise, my lords, they should
Very dangerous.
continue. If your lordship kindly sees page 28 at Annexure 4.
Please let us see. Mr. DSG, you give us a concrete one. Now he has flagged an issue that there was no permission which is extended, nor renewal. You have to take a decision and give us. And if it is not done, then you know what what steps you are required to take.
And already, according to telephonic instruction, what they have intimated to us, they have they have taken all procedure. They follow all the procedures whatever they laid down. Thereafter, this unloading loading for the purpose of this, it is going on. There is no contrary at all. This as per this,
What it is, the license granted for loading and uploading
comes
from a
order.
particular siding that has expired. Now the question is that in absence of any renewal or an extension or a fresh grant of the license, how can you permit them to operate? His grievance is that how they are operating without any valid license. It's I would say, evasion of a government exchequer.
yes, my lord, it is a vice versa, because they are telling the petitioner come to this honorable court, he is a husband of a sarpanch who given annuity to the railway. And he, after this defeat, he is coming and
I have
let us you place
number two, that's why I'm saying, my lord.
Mr. DSG, only thing is you have to
Yes,
disclose.
now I understand. Last may give 2 weeks time.
Content renewed or extended.
That's
all.
Last may give 2 weeks. 2 weeks time. Last may given.
Come after 2 weeks. Yes.
There is another, just one. There is another point which I have raised, my lords, that this is a scheduled area. So without a Gram Sabha, they cannot issue a license, my lords. That also they have.
We will consider. Let them come first.
Yes.
Say us license. If it is a license, then it's all right.
My
They'll see to it. After hearing the respective councils, it appears that apart from the other issues, one of the major issue which has been highlighted today is that despite the permission or the license having granted earlier, expired by flux of time, the operator is still using and utilizing the siding, and thereby causing the loss of loss of revenue to the railways. Stop. The learned DSG is requested to take a necessary instruction in this regard, whether the person who is allegedly operating from the siding has a valid license or permission from the competent authority to stop. This is the matter after 2 weeks.
May I pardon, Lord? I have filed, Lord, I have filed an intervenor.
We will consider
because
that.
the Lordship, all the allegation is against the Gram Sabha and I am the present.
Sir, we will consider it. Let the license come. Let us see if it is issued by Gram Sabha or Gram Panchayat, whatever, we'll consider it.
Therefore, my Lord, I am the Sarpanch. I can assist your Lordship better.
Yes, we'll see to it. Don't
Item
worry
number
on that
30.
day.
Obliged.
Yes.
Particular I am for the petitioner. It's a case of preventive detention, and the petitioner was detained on 24 January 2025 under the National Security Act. And my learned friend appearing for the state has filed the counter affidavit. I'll file a short rejoinder.
They are also filed. Central government also filed.
Yes, Union of India has also. Main opposite party is state of Orissa.
Yes. Main contest is
After, because he's no more under detention under the NSA, your lordship. He's now in the jail because of another case in GR case number 21 of 2025, your lordship, which is pending before the JMFC, Baramba, your lordship. I have. The state has detention was over on 23rd of April, your lordship.
After 3 months only?
Yes, your lordship.
Detainee was there for 3 months only.
Yes, your lordship.
They have not extended. My learned friend should.
No, they have not. Now you have gone in a correctional home in connection with another offense.
No, that is because I am in custody in connection with another offense regarding which plus ultimately the provisions under the National Security Act
unable to follow. Sir, with details of risk, because of this technical internet connectivity, I am unable to follow what you are saying.
Because my learned friend has stated that after 3 months it has not been renewed.
No, he says that he was definitely detained for a period of 3 months till 2025. Thereafter, he is not detained by the NSC.
No, Milos, he has been detained by the in view of the National Security Act. And that was Milos, only for a period of 3 years initially.
Now he is released therefrom.
They're saying, yes.
And now in a correctional home in connection with the another matter.
Yes, Milos. He has to be released on bail in that case. Only when he will be finally released. So my point was, I have challenged the order of detention. So that part can be heard by Lordship whether the detention is illegal or not.
Mr. Katkia,
Yes.
have you seen this instructions which?
No, I have not seen. I'll get a copy from my learned friend.
They must have shown. So sitting there, you cannot see.
I'll get a copy. I'll get a copy. Must let it be adjourned to some other day next week.
He says detainee has been released from NS Act on 23/4/2025 after expiry of detention period, but detained in this circle jail, Cuttack, as so and so, in GR case number such and such, pending before NSC such and such.
Yes, I have followed. Yes, I have followed. In case of another criminal case, he has been detained in jail custody. But I'll file a short rejoinder, of course, because I have challenged the initial order of detention. Why he has been detained illegally? So I'll get a copy of the instruction from a learned friend. Plus, I'll come back. You'll also keep the matter to next week.
If the detainee was there without any process of law being followed, then he's entitled to some kind of a rejoinder.
Only that, but
how soon rejoinder?
Plus, I'll file within 4 or 5 days. Plus, I'll call it on 8th.
The present petition. No, the order was Laku. Alleging that pursuant to the order dated 24th January 2025, passed by the District Magistrate Cuttack, exercising the power under subsection 2 of section 3 in the National Securities Act 1980, the petitioner was taken into custody illegally and in exercise and in excessive exercise of powers. It is alleged that the petitioner was incarcerated in connection with the other cases and got the bail, but subsequently he has been detained in connection with on the basis of the said order while already in the custody. Therefore, it runs counter to the mandate of law declared by the Supreme Court in Namina Begum versus State of Telangana, reported in 2023, volume 9, SCC 587. The matter was taken up on 25/3/2025 when the preceding bench took note of the aforesaid facts and directed the state to disclose their stand on the other day. So today, when the matter is taken up, it is submitted by the state that though the petitioner was detained under the NS Act, but for a period of 3 months, which expired on 23/4/2025. But he is still in custody in connection with the other case pending before the judicial magistrate fast track. First class. Judicial magistrate first class. Baramba. The counsel for the petitioner, however, pleads ignorance in this regard as he is appearing on a virtual mode and requested for sharing of the copy of the instructions filed today. Ms. Patnaik is directed to share the copy of the said instruction. It is further submitted by the counsel for the petitioner that he has received the copy of the counter affidavit filed by the state, and he may be permitted an opportunity to file a rejoinder to it. So, in view of the above, list the matter. In the meantime, the rejoinder may be filed. Yes.
Plus on 8th plus a specific date. Could you apologize, plus?
Oh.
Matter. These are the section 11 of arbitration matter for appointment of
Yes.
Lordship, I make to
mention.
Item 1.
That last orders.
Yes, who is for the other side?
I'm for the state here.
Yes, what do you say? There is already an agreement that contains an arbitration clause.
Yes, Your Lordship, we
Now the
filed,
dispute is raised.
we have filed an objection, Your Lordship.
What? That you do not want the arbitration to happen.
No, we have said that there is the executive engineer, Charbatiya division was a party to the arbitration agreement. He has not been arranged as an opposite party, Your Lordship, as a misjoint of parties. Secondly, Your Lordship, 8.2 clause.
Give me the file.
Secondly, Your Lordship, 8.2 clause of the general conditions of contract
Yes.
says about 8.1 says about amicable settlement, Your Lordship.
Yes.
Which states, Your Lordship, that is page 36 of the original petition, Your Lordship.
Yes.
Which states that 8.1 amicable settlement of disputes 8.1 amicable settlement. The parties shall use their best efforts to settle amicably all disputes arising out or in connection with this contract or the interpretation thereof. 8.2 states dispute settlement. Any dispute between the parties as to matters arising pursuant to this contract, which cannot be settled amicably within 30 days after receipt of one party of the other party's request for such amicable settlement, may be submitted by either party for settlement in accordance with the provisions specified in the special conditions of contract. Here, Your Lordship, they had given a bill to be honored. We had written, that is under Annexure A, Your Lordship, the superintendent engineer had written in detail why that bill cannot be honored, Your Lordship.
Correct.
We had given all the details.
Correct.
Now, after receiving this letter,
That means the amicable settlement, you are not agreeing on that.
no, Your Lordship, that was,
That shows that you have raised a dispute. And the moment you have raised a dispute that this cannot be paid to you, then this dispute is amenable to be determined.
yes,
And
Your Lordship,
who gets
that
determined?
they can come for they have never after that approached us. Straight away, they gave us notices for arbitration, Your
So
Lordship.
that means there was no amicable settlement in this regard.
They
What
have
for?
not come forward, Your Lordship.
What for? Just to have the same answer.
Your Lordship, that they could have
It's the
decided.
same answer.
We don't
It's a
know what would have
farcical-
been.
It's a farcical approach. Once you have conveyed your intention that it cannot be done, we can't pay you. Can you change your opinion and say that I will pay a rest? I will not pay the more.
But Your Lordship, that they have not, could have come for an amicable settlement. I don't know what would have been the result, Your Lordship, but that effort was not there from their side.
This is something, it's not is a precondition for this.
No, Your Lordship.
It's not precondition. Once you have denied, then the question is different. Because the purpose is that the parties, before raising a dispute, will try to amicably settle the entire disputes. If the amicable settlement is not possible, then they'll have to take recourse to any forum which you have agreed. This is what the forum they have agreed. Section 21 notice has been given. Is it?
They have given notices, but
Is the arbitration clause?
that is 8.2, Your Lordship, page.
No, it's not arbitration. This is the clause which is in accordance with the provision is specified in a special condition.
Yes, Your Lordship, page 43 of the petition. Eight point 2.1, Your Lordship.
And within 1 month, you have not appointed the arbitrator.
No, Your Lordship.
No response. Is there any panel of arbitrators which are maintained here?
The center, Your Lordship.
What? I do not know what is the mechanism here.
My lord, there is a panel of advocates, and basing the list of that advocate, my lord is appointing. This is the system.
What?
There is a panel of advocates, and the arbitrators list is there with my lord, and basing on that list, my lord is appointing one after another on the suggestion of both the councils, or lordship may suggest any name and we are accepting. The committee, including one by one, our judges, district judges.
Tell us, both of you, suggest a name.
Your Lordship may keep it to next week. I will seek a name from the department and whichever I will
What?
suggest.
No, you'll have to choose any one name.
I have to take the concurrence of the department.
Why concurrence? We are not going to record the consent on your part. Just choose both of you.
And you also any name.
Any name Your Lordship chooses.
I don't know. Which I follow there also. Both of you. Agreed?
Any name.
No.
Any name.
Which name?
Give it, let them. Both of you, just go through it.
Your Lordship, Mr. D.P. Nanda, Senior Advocate.
I The application under Section 11 of the Arbitration and Conciliation Act 1996 is taken out by the petitioner for an appointment of the arbitrator in terms of an arbitration agreement entered into by and between the parties in relation to a contract dated 20th December 2018. For providing consultancy services for authorities engineer for construction of HL bridge over the river Mahanandi at Gopinathpur connecting to Singhana, Pitha and Vaidesho in the district of Cuttack. Under the NABARD assistance through an engineering procurement and construction within bracket EPC mode. Stop. The said work was in terms of the World Bank projects, and the petitioner was awarded the contract after following all the procedures required in this regard. The said agreement postulates not only the commencement of the work from 20th December 2018, but its completion by 19/12/2021. So it further postulates that the total assignment period of the work was 84 calendar months. Which was divided into two components. That is 36 months for construction period and 48 months for maintenance, including the settlement. So, including the settlement contractor's bill. Though the period for completion was indicated, but the same was extended by the opposite parties, and after the completion thereof, the monthly the completion thereof, the monthly invoices were submitted for the payment. But the opposite parties have illegally and wrongfully withheld a sum of rupees 24,48,995. Stop. Immediately, the petitioner raised a dispute by causing a letter in terms of clause 8.2.1 of the now caused the letter raising a dispute, which is duly replied by the opposite party. Now, the specific stand is taken that the said amount is not payable to the petitioner for the reasons stated therein. First off, the sum and substance of the stand taken by the opposite party is that because of certain grounds, the petitioner is not entitled to the aforesaid amount, and therefore they disputed the entitlement of the petitioner to the amounts so claimed. Ms. Patnaik, the learned additional government advocate appearing for the opposite party, submits that clause 8 of the general, this is the general conditions,
Yes, Your
conditions of
Lordship.
contract. Imposed a precondition of the amicable settlement before the petitioner could invoke the arbitration clause. According to her, the petitioner ought to have approached the authority to settle the disputes amicably, and the moment the exercise, the moment the efforts for the amicable settlement fails, the arbitration clause can only be activated. But we would have appreciated the aforesaid contention had there been no demand raised by the petitioner and duly replied by the opposite party. The demand was raised by the petitioner, and the opposite party conveyed and communicated their stand on the said demand. That the claim is not tenable. Therefore, a dispute is raised by the opposite party on the claim of the petitioner. The moment one of the party has conveyed his stand taken in course of a claim having made, the laudable intention is manifested that there is no possibility of any amicable settlements. Stop. The moment the recourse to an amicable settlement would result in futility, evidencing the stand of one of the parties, it would be an idle exercise to relegate the parties to explore such possibility. Stop. The clause 8.2.1 of the special condition of contract contain the arbitration clause, and the dispute should be resolved by a sole arbitrator or an arbitrator panel composed of 3 arbitrators in accordance with the following provisions. The said clause is quoted is reproduced as under Code 8.2.1 at page 43. Give me that Arbitration and Conciliation Act. The said arbitration agreement postulates the modalities of appointing the arbitrator, and in the event the parties do not agree, within the time indicated therein, the authorities may be approached to appoint such arbitrator. Section 7 of the Act defines the arbitration agreement, which can also be in the form of an arbitration clause contained in the contract or in the form of a separate agreement. Section 11 within bracket 6 of the said Act postulates that whether appointment procedure is agreed upon by the parties, and if any of the parties fails to act as required under the procedure, the appointment shall be made on an application of a party by the High Court. Stop. The arbitration clause contain a time limit within which the party has to agree upon the arbitrator. And it is undeniable that despite the receipt of the notice, the parties have not communicated their decision of appointment of an arbitrator, and therefore there is no impediment, and therefore the provisions contained under Section 11 of the said Act gets activated. Since the dispute has arisen in relation to the payment of the bills, such dispute comes within the ambit of the arbitration agreement to be determined by the arbitrator. Stop. The application under Section 11 of the said Act is hereby allowed. Mr. What Nanda?
Mr. Durga Prasad Nanda, DP Nanda, senior
Mr.
advocate.
Durga Prasad Nanda is appointed as an arbitrator.
Senior advocate.
Yes, London senior advocate is appointed as an arbitrator. Can I fix a timeline within which, because then the extension has to be done? Yes? Can I?
Yes, your lordship.
Because this amendment has come later on, that's why I'm asking. Section 29A. That is, he's directed to complete the arbitral proceedings within the time indicated in section 29 capital 29 capital E of the said act. The remuneration of the arbitrator shall be paid in accordance with the schedule appended to the said act. Yes.
Sub-item, your lordship, the sub-item also we have the say, it relates to another district, your lordship, Jharsuguda, but we have to seek instructions, your lordship.
Which one?
The sub-item.
Okay.
Uh,
So sub-item detach and list the matter on next Friday.
Obliged.
Last time they are also. They come when they want instruction, they may come with a positive instruction that now they will be paying you.
Item number 2.
Item number 2 had we have taken also taken time.
Yes.
The consent decree is already 1 week time meanwhile with the tax.
Page?
Page 20. Plus 25, settlement of disputes.
It's a very clumsy and a very comprehensive clause for arbitration.
The provisions of there is an demand thereafter an appeal is
There is
there.
already a dispute resolution committee
that is the-
you have to approach.
Dispute.
Exactly, my lord. Exactly, my lord.
Yes.
I have exhausted all the provisions as per the contract. I have made a demand on 21st 1, thereafter the appeal in 26/2, thereafter the request for DRC on 16/4/2004, thereafter make a request on 2/12/2024. We have already exhausted the provisions.
Yes, what do you say?
My lord, kindly see the prayer. Because it has been written for the first time, I have to take system. My learner senior is already, DSG already said.
No, it's not.
Yeah,
First time, on 4th, they have taken time for instruction.
No, my lord, no, my lord. It is never been on board. It was listed. It is never been on board.
Yes. Yes, I think.
Admittedly, you have taken time, right? The consent executive is joined, lordship will give 7 days time. Next week, you can either his instruction authorized lordship are necessary.
You are appearing for whom, sir?
DSG.
DSG is appearing.
Yes, PK Padi sir is appearing.
And then who are you? Are you assisting or you are appearing for?
I'm assisting, sir. SS Kashyap, Senior Appellant Counsel, assisting Mr. PK Padi.
Then why you hijacked the senior's right to audience?
No, sir. My seniors, they are sorry.
Wanted a week's time. Wanted a week's next Friday.
Next Friday, yes. Next.
I have personal difficulty on 9th, my lord. Yeah, available.
16th. Next Friday, then next Friday. 16th, yes.
This month of this.
Item number 3.
Yes, give me.
The arbitration clause is at page number 129.
Page
129. And I have exhausted the remedy of conciliation.
129 is a. Where is the dispute which you have raised?
Malad, that is at page number 348 by letter dated 348, Malad, page number. This is also my letter for conciliation, Malad.
This is you wanted a conciliation has to be done.
Yes.
Then where is the demand for an appointment of arbitrator after exhausting this?
Yes, that is after that. After the next page, Malad. That is the 351 page number.
Serve a notice, service, returnable after.
The next item, Malad.
Call the next.
Item 4.
Yes, Malad. That is Union of India is the party, Malad, East Coast Railway. Herein, my lord, the general standard condition of contract is to be followed, my lord.
Yes, give me. Where is the arbitration agreement?
My lord, here, my lord.
Page.
I'm saying, my lord. As contrary to the agreement, general standard contract, the general condition of contract of railway has to be followed, my lord. And by the letter of East Coast Railway, they have admitted clause 64 of that contract has to be complied with. And my lord, I'm citing that page, my lord. That is at page number 448, my lord.
That was in respect of liabilities.
Yes, ma'am. If there is any dispute during the execution of work.
Where is your letter?
Well, prior to that, that is at 439, page number 439.
Serve notice.
I am appearing for the Union of India. Let him solve the court.
Yes.
I am appearing for the Union of India. Let him solve the court.
Yes, we are given a notice. Yes.
Item number 5.
5 minutes, my please, Lordship. Arbitration clause is page 76, my lords. Page 76, clause 4, my lords. 25.3. Page 76, my lords. The agreement starts at
P76 or written 76?
P76, my lords. P76. 4, my lords. 425.3. Read with F, my lords. The next page.
Where is the demand?
Page 121, my lords, note.
What?
121, my lords, annex to 8, my lords. And thereafter, my lords, peculiarly in this case, my lords.
There's a
121, my lords. And
any reply was given?
my lords, after that, my lords, very next page, my lords, this is a peculiar, my lords, at page 123, my lords may kindly see at annex to 9, my lords, what they've written. Appointment of arbitrator in mutual consent. With reference to the subject cited above, I am to say that on behalf of your clients, as per your request made to the MD Osdama by letter number such and such.
Agreed on the senior advocate.
They have already appointed. They appointed on the names which I have given. They didn't consider that. They have appointed, and I have given my consent also.
Oh,
my lords. Thereafter, I have given my consent on the very next page, 126, my lords, and 126, my lords, and peculiarly, my lords, unilaterally on page 127, they have again withdrawn, my lords. They have given
this,
my lords. Last occasion also that
Notice has to go to Osdama, Your Lordship.
principal employer is Osdama. That is Orissa disaster management.
Your Lordship,
then we are appointing.
My lords.
Your Lordship, we are actually appearing for the first time in this matter.
So whatever the letters, can you deny?
Your Lordship will be.
You have admitted two things. One is, yes, there is a dispute.
Yes.
First admission. Second, yes, the dispute is liable to be decided by an arbitrator. These are the two components under the Act. Both of them you admitted. They suggested three names that you can concur with anyone. You suggested your own name. No. I wanted this arbitrator to arbitrate. They say, I agree. Later on, you say, I withdraw. I do not want that arbitrator to work. What more? What instruction and what pleading you will do? Tell me.
Your Lordship, we'll be taking instruction on two folds. First,
Sorry,
to,
nothing. Because
appointment of
had it been a case that you are saying that there is no dispute, they have not followed the law, they have not followed the clause in the proper spirit, I could have understood and I gave you an opportunity. After looking at it, when you yourself has admitted the dispute and appointed the arbitrator, which they agreed, then what remained thereafter? What remained? Then we'll appoint an arbitrator.
Your Lordship, as a matter of last opportunity may be given to file a wakalatnama and to take instruction. Just
wakalatnama next week is 9 months.
Oblige, Your Lordship.
Item 6, 6, 7, exactly the same.
5, 6, 7, Your Lordship.
5, 6, 7.
I'm appearing for Mr. Sonak Misra, for my senior.
We require you, sir.
Indeed.
Item number 8.
Oblige.
All three on 9th months.
Yes.
Oblige,
Item number 8, my lord, page number 128 is the arbitration clause, my lord, the dispute resolution clause.
Page
number 128, my lord.
And where is the demand?
Demand is at, my lord, page number 634, my lord.
Six
34 month. Annexure 9.
You have named?
Pardon me, madam.
You have named the arbitrator?
Yes, madam. Honorable Justice.
But they are not. They have not. Have they responded?
No, madam. No, it's a fresh matter.
Service?
Yes, madam.
Item number 9.
May I please, Your Lordship? Your Lordship, in this, my senior
I'm seeking Lord's permission to appear through VC, my lord. I'm appearing from Delhi, my lord.
Lord, my senior Sri Upadhyay sir is appearing on VC.
The arbitration clause, my lord, would notice on page 18, my lord, the four-tier system, my lord. Annexure 1, my lord. And the clause is note 3.57, settlement of disputes. First with Lord Engineer, then Chief Engineer, then Engineer.
I'm looking at the clause, sir. Just 1 minute.
I'm so sorry.
So it's a 3-tier filtration which is provided before it reaches the arbitration.
Yes, my lord.
Have you accepted that?
We did, my lord. We did comply with all of them.
Show us.
Yes, my lord. My lord, the first one, my lord, would notice on page.
Gone to the engineer.
Lord, we had gone till the additional secretary level.
Or
So
you have
first,
gone to.
my lord, I will draw Lord's attention first on page 38.
Annexure 6.
My lord, yes. Annexure 6. My request to superintending engineer.
Yes.
Reason being, my lord, the executive engineer, superintendent both were same, my lord. That document is also on record. Now that denial has come on page 62. Superintendent my lord, rejects my request.
Denial at page
62, my lord.
62.
My lord.
Yes.
Then,
So
my
you
lord,
have,
the second request is 58. I beg your pardon, my lord.
have you gone further?
Yes, my lord. Page 58, annexure 7.
To whom?
To executive engineer, then chief engineer, page 64. Then secretary, page 177.
Yes, serve a notice. Serve a notice.
Yes. Deeply obliged.
Deeply obliged.
For orders item 10,
May I please, your lordships? Sir, IA has been filed in the disposal of arbitration application for extent. An IA has been filed, my lords, in this arbitration for extension of time for the arbitration, my lords.
Copy notes or my lord.
Right, so, we have telephonically had informed them. They told that they will be receiving it in the court. So.
For next week, my
What do you say?
for next week, my lord. Next week.
Next. What is your good name?
Chandan Kumar Rao.
So Chandan Kumar Rao, appearing for the opposite party. Submits that the copy of the IA such and such has not been served upon me. So the petitioner served the copy of the said application in court today. Stop. He prays for an accommodation to peruse the amendments made therein. Place the matter on next Friday.
nice. Item number 11.
May it please, my lord. My lord, that I have filed an IA for modification of order dated 30 October 2024, my lord. My lord, here the claimant preferred an application under section 11 seeking appointment of an arbitrator to adjudicate the disputes in the arbitration petition. And here I have filed and this honorable.
Then where is the difficulty? What modification you wanted?
My lord, my lord, kindly have a glance upon the order dated 30/10/2025.
I have read it.
My lord.
That's why I'm asking that what modification you want.
My lord, on 31st January 2025, honorable arbitrator recused. Therefore,
So it's not a modification.
My lord.
It will be a fresh appointment on the basis of the refusal on the part of the arbitrator.
My prayer is that, my lord.
Can you do it in a disposed of matter? I'm asking you. Can you do it? Just show me. This is a disposed of matter, sir. Can you do it? Look at section 14. Really a termination of a mandate of an arbitrator, then you will have to file a fresh application under section 11.
My lord, in that point of light, I
Would
will
you like
prefer,
to
my lord.
continue or like to withdraw, whatever?
My lord, withdraw. I prefer withdraw, my lord.
I withdraw with liberty to file an appropriate proceedings for the sales and reliefs.
Item number 12.
Item 12, it has come up for acceptance of late requisites. That high.
Requisites have been put in late. The requisites put in out of time, we accept it. Office is directed to office or department, what? The office is directed to issue notices upon the opposite parties immediately. After 2 weeks.
Item 13.
Madam, my lordship, pray for 3 days time to file the requisite, lordship.
Extension.
No, lordship, I have not filed the requisite in.
The time to put in requisites is extended by 3 days from date. List the matter thereafter.
Right. Item number 14.
Yes.
Item number 14, my lord, is a case of contract, my lord. The original content filed before
Why
the
single bench?
Yes.
Why single bench? Whose order? Why it has come to me? Then why it will come to me? Oh, contempt? Why is the Chief Justice to be sending notes?
Earlier there was assignment.
Like, kind of. Achha. No. It will go to the respective bench. Place it. Stop. Let this matter be placed before the Chief Justice for passing an appropriate for assigning the matter to an appropriate bench.
Earlier the assignment was.
I have seen that assignment. There are many. Why
Yes,
it has to come to the chief? I do not know. Why not? Finish it.
Item
Everybody is
15.
waiting.
Right. Item 15.
Lords,
this is a case, my lords, during pendency of the arbitration proceeding, the presiding arbitrator as well as our arbitrator passed away. So I filed an application under 11.6. By following the procedure, I gave a notice. Your lordship may kindly see the notice which I've given them. That
So
is
why there was a direction for rejoinder and counter in this case? If there were already an arbitrator appointed and two of them has died,
there was no
who is for the opposite party?
is in the
I'm for the opposite party, Your Lordship.
Where is the difficulty, sir?
Your Lordship, the section 11 has already been sanctioned. If you see the list of dates, Your Lordship, an arbitral tribunal was formed. Within that, the arbitration proceedings was on, Your Lordship. And during the year 2012, they filed a writ petition against an interim order, Your Lordship. If you
passed by the tribunal.
Yes.
Yes, Your Lordship. The arbitration proceeding is not dead, Your Lordship. It's on. Right
No,
now, in between.
Sir, they are the two of the arbitrators. They have expired in the meantime.
Yes, Your Lordship. But Lordship, I want to take you, the Lordship, to the section 14 of 96, Your Lordship.
That's when the mandate of the arbitrator terminates.
Yes, Your Lordship. In between, both of the arbitrators have.
They can come under section 11. No difficulty. Where is the difficulty? It will not end, sir.
No, Lordship. I'm just trying to. I'm keeping my say, Lordship. The arbitration proceeding is on, Your Lordship. The arbitrators have expired in between.
A dead person, it is on. Tell us. Before a dead person, it is on.
No, Lordship. Right now, what I'm suggesting, Lordship.
There are three arbitrators. Two of them are dead. Then our arbitration proceeding is on. Before whom?
Lordship, the arbitration proceeding is on. What I'm saying, Lordship, when the arbitration proceeding was going on, they filed a writ petition before this Honorable High Court against the counterclaim. That was not the final verdict of the arbitral tribunal. Then, Your Lordship, in 22, both of the arbitrators expires. In 23, this writ petition comes before the Honorable High Court. They withdraw the petition and they file again section 11.
Sir, straight away look at section 15 of the Act. I think that is the complete answer what you are talking about.
Your Lordship, section 14A. Your
I
Lordship,
am talking about look at section 15. Is a complete answer what you are arguing.
yes, Your Lordship. If the appointment is made,
Substitution.
Yes, Your Lordship, the substitution has to be made before the district judge, not before the Honorable High Court through 11, Your Lordship.
I am talking about the district judge appointed it. Who can appoint an arbitrator? Suppose the parties, they do not agree. Where is the power under the Arbitration and Conciliation Act conferred upon the district court or a district judge to appoint an arbitrator? Under section A and E?
He has to go under 14A, Your Lordship, when he becomes de jure or de facto.
Of a court? Tell us, what is the definition of a court under section 2E?
Yes, the principal civil court of original jurisdiction in district and includes the High Court in exercise of
The
its
other side of the High Court. Had there been a subject matter of the suit, read signs.
Your Lordship, with this issue, there are some judgments I have to.
I am giving you a imbue judgment.
Lordship, I want to refer to a judgment, Your Lordship, that has been dealt with in Calcutta High Court in Tantia Construction Limited versus Union of India, Lordship.
Who is that?
Lordship, if I may, granted 1 week, I will be present physically. I can present you the case, Your Lordship, by hand, Your Lordship. I have a good judgments in my hand, Your Lordship, to prove my case.
And there is one judgment in my mind, which I delivered there and decided it. So that's why I'm saying.
Yes.
Sir, I have already decided this point and What can I do?
I just want to
So
clarify my point.
prove me wrong. I am ready to correct myself. Don't worry.
No,
My
no,
mind-
no, I don't want to prove along.
I
Just
have
I want to
committed
clarify my
all
point.
I have to accept it. Don't worry. Yes, come in next Friday on the prayer.
Oblige your lordship.
Item 16.
Here, my lords, the arbitration
I
clause.
appear for the respondent, my lord.
Arbitration clause is at Annexure 1, page 24. Clause 12.
Where? Page?
Page 24. Clause 12.
Or I can't. This is what they have filed or we have taken for the court.
Not very clear. That's not very clear then.
Look at it. I can't read it. Can you give me a better copy?
We would.
Or can I get it a better copy here? Item number 16.
It is there. It has been quoted also.
Page.
Page 24 is the original one. It's quoted at page number 4. Part of the raising contract agreement. Page number 4 of the petition, it is quoted.
24, I can understand. Yes, if the
Clause 12, that if any dispute
is not resolved, then unresolved dispute may be referred to the named arbitrator.
Named arbitrators.
And then
one
what?
of them is a CA of our own company.
Okay.
So in view of 12 and the schedule.
No, and there is another retired.
Mishra IAS, he's passed away.
Oh.
He's not there. So with this kind of a clause, we had filed an application and the notice invoking arbitration, my lords, is that.
Have you served?
Yes, he has appeared, his file.
My lord, I am appearing for the response. My lord, I have preliminary objection to.
What is your objection?
My lord, first of all, this is a second round of 11 that has been filed. The first was filed before the Honorable High Court at Madras. The Honorable High Court came down heavily upon them, imposed a cost of 1 lakh on two grounds, my lord. Territorial jurisdiction, abuse of power
That
of
is
law.
not a decision on merit, sir.
Indeed, my lord, allow me just one more submission, my lord. My lord, my basic premise is there is a judgment of the Honorable Supreme Court. I'll provide the judgment, my lord, 2015 KSS versus Gale, which says that under the exercise of the power of 11 clause 6, my lord, not only the existence of arbitration agreement, there shall be a considerable arbitrable dispute, my lord. Now, having said this premise, my lord, I come to the fact.
I'm asking you, is there any dispute? First thing is,
My lord,
I understand. I was going to ask, is there any dispute raised by the parties?
My lord, in regard to the petitioner, there are certain dispute, but not under the agreement.
Now, second is, what is the nature of the dispute?
My lord, the nature of the dispute is, if we go through their arbitration notice, my lord, under 21, they say that we have come to know that you have filed several litigations or FIRs against some other person who is not a party to the agreement. They seek us to stop us from filing those litigation. And why I say this, my lord, my
What are you talking about? That is a dispute. Show us.
Page 86. Annexure 8.
Where is the agreement?
Agreement is
No. That letter. Sorry.
My lord, page 86.
Yes.
Page 86.
And 88, my lord, and para 4. If my lord will.
Just 1 minute.
Sure, my lord.
Paragraph 6 and 7 at page 88.
Even 5, my lord.
Now tell me that all these clauses,
Indeed,
6 and
my lord.
7, these are one of the terms and condition of a contract.
Yes. So, my
Can you show me whether these are the part of the contract?
here, the first principal contract is
Because installing the lease renewal.
My lord.
Where is the clause? Sure.
My lord, may kindly see. There are three agreements between the parties. The first one is Annexure 1, the raising contract.
My lord, I may object, my lord.
Don't interfere.
Third one, the second one is Annexure 3, which is a tripartite agreement between the petitioner and the opposite party and one more company.
Correct.
Annexure 3 doesn't have an arbitration clause.
Correct.
And then there is an irrevocable power of attorney.
We are not concerned.
Which
We
doesn't have
with the first agreement.
First
which
agreement.
contains. Then
now, my lord, may kindly see Annexure 1, page 18. That's the raising contract agreement. If that is not legible, then I have to.
No, it is with a lot of amount of taxing which I have to do.
Then my lords, I'm so sorry, my lords. I will put a very neat copy. Your lordship may keep it to
Or
me.
get it typed and give it.
We would. I'm so sorry.
Next Friday.
Item 17.
Next week. Can I?
Next Friday.
Next.
Next Friday. Grateful, my lord. Grateful.
Item number 17.
This one on 11/6.
Notice has not been delivered.
14 and 15, my lords. I think
17 or 18.
17.
17.
Notice has not been issued.
No, notice.
My lord, I
There,
have instruction to appear on behalf of the respondent number 1.
So give him a copy.
I'll give it.
What is the good name, sir?
My lord, Prakash Ranjan Behera and Associates.
One signature.
Though
No,
the
copy.
postal article
I've already submitted a copy earlier.
sent to the opposite party number 1 has not returned in the department.
It's not returned, correct?
But Mr.
Prakash Ranjan Behera and Associates.
Prakash Ranjan Behera and Associates appears on instruction from the opposite party number 1.
Right.
On the instruction of the opposite party number 1. Stop. The copy of the application may be served upon Mr. Behera. How?
On next week, my lords. Next week.
By Monday
Monday.
or Tuesday?
Tuesday, my lords. It'll be better.
Tuesday. Matter to appear after fortnight.
Item number 18.
The opposite party, my lord, on behalf of Mr. pray for next week.
No. Who is appearing for the opposite party number 1?
Both the opposite party, for both the opposite party, Mr. Tanmay Mishra.
He? Where is he?
He has some personal difficulty today, my lord. Any day.
Can you receive a copy on his behalf?
Already
I have
notice was
already
issued. Yes.
received my-
Oh, you have
already
already
entered into appearance.
Next week. Next.
Item 19.
My lord, this is my application for appointment of arbitrator, my lord. My lord, notice was issued already.
But service has not been shown. That's why you are appearing.
I'm led by my senior, Mr. Pangari Miller, who is online. We have already received. I'm just filing up. We have just received instruction to appear, madam.
Yes. Would you like to file any pleadings or something?
My lord.
Yes.
3 weeks time. Let's say 3 weeks time. We need that final.
2 weeks time. 2 weeks time to counter affidavit.
2 weeks.
It's matter to appear after
20. After vacation, my lord. Deeply obliged.
Next.
Grateful. Item 20.
Obliged.
My lord, item 20, it did not return.
ID card is neither returned, nothing. It appears that the service has not been affected as yet.
After vacation.
Let the matter be listed in the next week, but it means next Friday.
Yes, ma'am.
So the office is directed to submit the fresh service report.
Item 21.
21, my lord, I am appearing from the petitioner. In this case, notice was issued. In the meantime, the opposite party number 1 has died. I
You'll have to
have
take out an application
he already filed an application for substitution, my lord.
within time or out of time,
Within time, my lord.
90 days?
Yes,
or
my lord.
beyond 90 days from
No,
the
no.
date of the death?
No, within 90 days, my lord. Date of that is 19/4/2025. Date
Show
of
us
death.
that.
Yes, my lord. IN number 14 of 2025, my lord.
When he died, 19/4.
19/4.
And when the application 28/4.
28/4.
Yes. Record. The instant application is filed by the petitioner for substitution of the heirs and the legal representative of the deceased opposite party number 1, who died on 19/4/2025, who died intestate on 19/4/2025, leaving behind him surviving the
In the schedule, my lord. 1A to 1D.
him surviving the living Kibalichi, surviving the persons named in the schedule appended to the said application. Stop. From the description of the heirs and legal representatives given in the schedule, it appears that they are major and sui juris. And capable of representing themselves. Full stop. Since the application is taken out within a period of limitation and is informed, there is no justification in rejecting the same. The application is allowed. The heirs and legal representatives, as shown in schedule to the said application, be substituted in place and state of a deceased opposite party number 1. Stop. Service to be effected upon the substituted opposite party number 1. Requisites within 3.
And I am appealing for OP number 2.
They have to be submitted.
Item 22.
Next time is same, my lord.
Same opposite party number 1.
Yes, my lord. There is 2 partnership duty.
After vacation.
Good.
Yes, next.
Item 23.
Here the service not shown, my lord. AD and other not at all.
Same next Friday, fresh.
Item
Service
20.
report.
Yes. Item 24.
Same thing.
Notice was issued. It's not tracking.
It has not been served.
Yes.
Next, fresh report.
Item 25.
Receipt, 3 extra copies.
25, I am filing that counter. Last week, yes.
You are filing a counter.
Yes, but I am giving serving copy to my landlord.
The opposite party files, opposite parties.
Yes, my parties.
Opposite parties files the counter affidavit in court today. Let the same be taken on record. The copy whereof has been served upon the learned advocate appearing for the petitioner in open court. Stop. Liberty is granted to the petitioner to file rejoinder dealing with the averments made in the counter affidavit within 10 days from date. List the matter after. No. Over. Yes, thank you.